broken baker, where crimes are baked in every show. Mysteries rise and truth unfolding. Ready, set, it's time to go. We say it's time to go. Listening to battering news, mixing stories, solving the lies. In this kitchen, secrets are broken. With a spark in our eyes. In the broken baker's kitchen, the secrets crumble like stone lights. We'll sift the blues, define the news. With a spark in our eyes. Broken rise. Broken rise. Welcome to the broken baker. Get ready. Let's go.
I'm Jimmy. How y'all doing?
The most important people in this case that everybody seems to have forgotten in this room is the jury. So we're going to take a 15-minute break and both sides take a pregnant pause and think about the jury.
Hey everyone, welcome back. Everything went a little fast. Mo is also here now.
Yep.
Yep, we are still victims of our own physiology, even though we are YouTubers.
Yes, we
But
are.
interesting development this morning. For those of you who weren't here for our little impromptu morning stream, a motion has been filed. If it has any validity, we don't know. That is for the court to decide. But the state at least alleges that there is some kind of conflict of interest with a media rights deal on behalf of the defense team and Sarah Boone, which is going to be interesting to see if it has anything. The state wants to see the financial agreements. I don't agree with that. The state should never have any right to see that. The judge, on the other hand, could have a look on it, ask Owens if he had made a false statement to the judge by claiming he was pro se when he clearly, because his client must have signed a piece of paper stating he had the rights to her case, that he lied to her claiming he was pro bono. So the state should never see the agreements. I totally agree with Ronkel on that one, but it's a different matter with the judge. Oh, she's in a red today.
It almost looks like the same one from yesterday, but I think it's slightly darker.
Hey everyone, hey everyone, hey everyone. We're sorry we're back.
Deep side part today.
Yeah, she's looking wonderful. Well, hope everything goes well, Tammy.
Yes.
This is a long piece stream. Must have been a great process. Mo and I was what you don't know about most of us creators is we are sitting here thinking, can this stream ever end? And then we talk for 10 hours afterwards in the green room. Hey, Tash.
Yeah.
Hey,
Even though
Kay.
we both said, like, we both need to use the bio break before our next stream. And then we're like, jib-jabbing, like schoolgirls. We really are.
Dream Suburb. Been a second. And Renee. Helen from Holland. Did you... yeah, I told you what it was about. You asked on the other stream. I hope you're up to date. Hey, Jar. I'm getting a little Dr. Pepper, if you know what I mean. Well, as we call it at me and Sarah's house, a doctored pepper.
Yes.
FSB is, I believe, the Russian intelligence service that took over after KGB. Hey,
Makes sense.
I know stuff. Owens just claimed he was not aware of the motion. Judge tells him it was emailed to him. Then Owens states, I haven't read it. Well, he wanted to go to the Starbucks down the corner, use their Wi-Fi. But then a brown bear attacked him and stole his laptop, so he couldn't use the Wi-Fi. That's how it happens. Hey, Debbie.
He has to go to Staples or Kinko's or what was it, FedEx. Has Owens been aware of anything during this trial? He's always like, we filed a motion yesterwember and case law.
Yeah.
Case law.
Even
a Miranda motion where he didn't put Arizona or Miranda versus Arizona.
It's just part of it. Everyone knows the Miranda rights. Come on, Mo. You don't need to come on. Everyone knows that. They have a right to profit off their own crimes in Florida, but there is in Denmark we call it a key to how you share the profits, and we read that part on the last stream. 25% must go to her dependents, 25% must go to his dependents, and then I think 25% must go to the state to recuperate their expenses.
Oh, did the state get big posters for rebuttal?
Maybe it's just leftover posters.
We missed the fist bump this morning. Owens is kind of in his own little world.
Starbucks bear need laptop to watch YouTube during hibernation. I agree.
Makes sense.
It could be. Changed my name because of those doggies. They are innocent, just like Karen. Well, I, for one, doesn't support the terroristic threats that the dogs are making in Canton. I find it very, very horrible that they terrorize that poor pizzeria. It's almost
like... It really is quite... Would we call it terrifying love?
We call it shock and horror.
Oh, okay, Thor. Yes, I love you too. This is Thor. He is a non-consensual cuddler.
Well, Jessica, go have fun with the white sharks. I'm going to swim with sharks. No, I don't like sharks. Hey, mom of 10. They needed A2 posters to make sure the jury saw that sit that needed stitches. Yeah. That was some of the worst injuries I've seen in my life. Hey, Ronnie.
I don't understand her stories about the violence. Do I believe that they both were combative? Yes. But I don't get again, going to sleep is something completely irrational to me. Leaving the dogs when she claimed that the dogs would be hurt. She left 2 dogs, one that can't see, one that can't hear, with a dangerous, violent person. And then the television breaking video, I thought it was going to be something completely different. It was advertised and kind of pointed out.
It's and again, he could hardly swing that bat, but he was so enraged he trashed the TV in front of me. Then why was he saying, I don't want to, I can't. He didn't say, I'm gonna effing do this to you. Jamie is right now in the southern parts of the Amazons. For those of you who have watched Narcos, you know that Escobar imported a lot of African animals, and when his compound was taken over, they got released out into the Amazon. So Jamie is down there helping regulate the hippo population. They have become a big problem. So Jamie is capturing the hippos and taking them back to Africa so they can go live on a farm in Africa instead of living in a jungle in South America.
Yes, you need a bath, sir.
Bum, 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 bum. Jamie does get around. Yes. Did I send her? Yeah, I
She
sent her a link.
is.
Yeah. It's Thursday. Thursday is her phone day. Tuesdays and Thursdays.
It is really. So I went on X yesterday to see how people were kind of relating to the expert, and it was not positive. I did try to look for both sides, but I think they picked the absolute wrong expert. I think they were in a corner though, because the first gentleman they got to not, actually look at Sarah was actually, I think, a better one that would have connected more with the jury. I think she did that upspeak therapist talk where no one takes accountability, that really turns people off from therapy. And then she said micro traumas and everyone else was out. I know I was out. I was like, so if the McDonald's guy asks me if I want cheese on my hamburger, is that a micro trauma?
That's such a stupid. I had a buddy who actually went in, ordered cheeseburgers, and had them take the cheese out, and said, "Why the f are you paying 2 Danish kroner more for that? Because it's just a hamburger with a slice of cheese. You can just order a hamburger. No, it doesn't taste the same. It's a hamburger. That's so stupid."
You are ridiculous, sir.
Well, limited fund, limited time. She had 9 meetings with her. That's not that limited.
No, and so they're paying travel for every time that she goes in there. She's charging travel. She's charging, work hour fees. This is so ridiculous. Sarah, stop waving to your girlfriend or your one. Yes, you ridiculous cat.
He's a big purrer.
Yeah, he's not at all a fan of Dingus coming in and getting any sort of attention.
Hey, Trial TV. I hope it's a wonderful time in Florida. Is it you Sarah is waving to all the time? Have you swooned her? Have you sent her
Did you offer her a Diet Dr. Pepper?
Or a handle of vodka? But I hope you have a wonderful time. We saw you on television one day. The lady that kind of smiles to the camera. That's she's with Trial TV Live. Nice people.
Oh, cool.
Very nice people.
Yeah, I so appreciated them sharing their feed when they were doing voir dire. I thought that was really cool because, a lot of times we don't get to see that as much, and it was really cool to see that.
I just find it extremely boring that they're asking the same questions 45,000 times.
I don't know. You always get that one person like me, though, who's like, yeah, I do trial streaming, kind of weird.
Sarah Boone announcing for the record against the state.
Chief Catchatory on behalf of the state, William J. for the state.
Defense.
James Owens for Sarah Boone.
Tony Henderson for Sarah. Have that.
Ms. Boone, raise your right hand to be sworn, please. Do you swear or affirm the testimony you should give shall be the truth, the whole truth, and nothing but the truth, so help you God? I do.
Good morning, ma'am. Could you state your name and date of birth for the record for me?
Sarah Boone, 10-10-7-7.
Ms. Boone is seated at counsel's table, buttressed by her attorneys wearing a
Thank you, Wendy Joe, for being a member for 4 months. Hey, and good morning. Good morning to you as well.
black suit and pink blouse. All members of our jury are present this morning. State, is there anything we need to address before we bring in our panel? Defense, anything we need to address?
Yes, Judge, I intend to introduce these two exhibits that have already been stipulated to. One is, you did a walk in course of anything.
Right now, your ID is.
Well, it hasn't been paying millions. Let's just say that.
Defense Identification AB, Judge, which is the order dated June 16th, 2019. It's a no contact order. And then identification, AC. And it is a no contact order.
I want to go back to the gym, but I haven't been to the gym since last week because of my little tummy.
And then I'd like to hand publish them to the jury.
Well, don't try to kill it when you first go back. That's always the mistake. You're like, I used to be able to lift these up. And then you're like, I'll just stick with the 10 pounds.
I guess you would excuse the jury because.
Yeah, that's weird that they're not going
And
to
there
talk
may be
about the
additional
motion.
motions to be addressed at that time. So yes.
Do you want to do that now or really during?
I don't have a problem with that. If you want to rest now, subject to those being entered and published, and we can address any motions, the court has reviewed both of the no contact orders. And that way we don't have to do a in and out, and I can colloquy Ms. Boone at that point in time, and we can proceed with the state's rebuttal case.
Subject to those, the introduction of those two exhibits just mentioned, the defense would be resting our case at that juncture.
Okay, all right. Okay, I've been advised by the courtroom deputy that juror wearing badge 130, seat 10, cannot stay past 5:30 today. So just be advised, we'll use our time accordingly.
That one of the six.
I don't believe so. Give me a moment and I can check. That is an alternate. It's alternate seat 4.
Thank you.
Defense, do you have any motions?
Just out of abundance of caution, I would read new or motion for judgment of acquittal. Showing defense resting. We'll do that now while the jury is still out. I don't have any additional arguments other than what was made the other day.
Okay, thank you. Any other additional argument, Mr. J?
Just that at this point in time, the standard is whether or not a reasonable trier of fact could find the defendant guilty, and there is sufficient evidence for that to be sent to the jury.
Okay, thank you. The court recalls the arguments that were made after the conclusion of the state's case, both from the state and the defense. The court finds that a reasonable juror could make a finding of guilt on the elements of the sole charge and the information beyond and to the exclusion of each and every reasonable doubt. For those reasons, the renewed judgment of acquittal is denied. Ms. Boone, I have a couple of questions to go over with you, ma'am. You've been previously sworn this morning. Your attorney has indicated that all of the evidence and testimony of all witnesses in your case have been presented to the jury, with the exception of the 2 no contact orders pre-marked as AB from June 16, 2019, and the no contact order of June 19, 2019, pre-marked as AC, which once the jury comes back in, he will enter into evidence and produce them to the jury for their viewing. Are there any witnesses that you wanted to call that your attorney failed to call?
No.
Is there any evidence that you wanted your attorney to present that any of them failed to present?
No.
Are you satisfied with all of your attorneys up and until this point?
Very.
Very.
Is there anything that you would like to bring to my attention at this time?
No, Your Honor.
Okay, all right. I did receive the proposed jury instructions this morning. I'll look at them during the lunch hour, and after the state concludes their rebuttal case, we can proceed with addressing those. Mr. Beck, yes, sir.
No, the defense did not receive the red line copies that the court discussed yesterday. I don't know if those were sent or not.
I emailed Ms. Barrios last night. Once we got out of court, I'll send them to everyone this morning. Just give me a moment and I'll get those out right now.
So I do
Is there
wonder
anyone
what
else? The email.
the jury is going to make of the body cam videos, because we've heard the defense didn't do a lot to sort of elaborate on. They just had the deputies come in, say, did you show up at such and such a place? Did Sarah Boone have marks on her? I wish I were in the court so I could see the jurors when they start to see the body cams, because again, these are incongruent with someone who's had a lived experience like these. Calling a police officer baby, like honey, sweetie, lovey, it's very tonally odd to me. I know someone's going to pop up and say people react with stress in different ways. And yes,
But-
I can't verbalize exactly what's wrong, but if you've lived this, you know something is wrong with it. There's
But
something.
you see her, the roller coaster with her in those videos. You can see she's highly unstable. She's not how she was described. Always trying to hide, always walking on eggshells, always trying to protect him or everyone. The only thing you can say that shows that is in the beginning where she said, "Can you take him without saying it's me?" And then she starts yelling, George, come back. I want to go with you. So again, if they listen to all the classical signs of BSS, she shows none of those in the especially that one. Hey, the cops are here video.
Correspondence that I have is Mr. Owens' email, Ms. Andrews' email, Mr. Cacciatore's email. Is there anyone else that may need to be sent to from the defense side?
Yeah, that one, the skipping video.
Okay, all right, very good. All right, can we go ahead and bring in our panel? State.
Yes, Your Honor.
Defense?
Yes.
All right, let's stand and bring in our panel, please.
I want a hug. I want a hug. Can I get a hug? You can see she's highly, highly emotional, unstable. She's not a little flower hiding. And she's way too friendly with the police for someone who's been in contact with them that much.
Jury's entered.
Will you stop with the mic? It doesn't love you back. Stop.
State, you recognize our jury?
Yes, Your Honor.
Defense, you recognize our jury?
Yes, I did.
All right, thank you. Y'all can be seated. Good morning, members of the jury. Welcome back to 12 Alpha in the Orange County Courthouse. If you could, just raise your hands to confirm that you complied with the court's instructions last night during the break. I thank you. Record will reflect that all jurors have raised their hands. We're going to have a little bit of additional evidence presented by the defense this morning, and then we'll go from there. Okay? All right, thank you very much. Mr. Owens, you may proceed, sir.
At this time, I would like to introduce defense identification exhibit AB and evidence. No objection to AB or AC.
What was pre-marked as defense AB will be received into evidence without objection as defense 19. And if you could just identify AC for the record, sir.
At this time, I would like to move defense identification AC into evidence?
Hearing no objection from the state, what was pre-marked as defense AC will be received into evidence without objection as defense 20.
And Judge, I would like to publish these to the jury and allow them to take the time and pass these down to.
You may proceed.
The first is Defense Exhibit 19, which just review it, pass it down. Next document is Defense Exhibit 20.
Talking about that book deal, I can see people talking about, oh, everyone made a ton of money. I was a shitty mom to my son that made me drink because I didn't want the responsible to have him. My claim to fame is I lost the contents on Nickelodeon, and then I started drinking. I've been in relationships that I ruined because I am aggressive. But totally buy my book. Yeah.
You know, if
Bestseller.
if she calls it My Struggle, the suitcase, you know, and My Struggle.
Yeah, and with the paperclip hanging off that little zipper thing.
I mean, I'm here for dramatic readings. I am not above it at this point. I will buy her book, her little coloring book. It'll probably be it'll be longer than Lord of the Rings.
Yeah.
It'll be a 3-parter.
Part
Because
3
she'll start with her childhood.
Prison Messiahs, part 3 of the book, will be the first couple, my life, 5 pages, my relationship, 2.5 pages, 568,000 pages about prison messiahs. Everyone loved me. I was held in solitary because people were too envious of me. I was the smartest person in the prison. I didn't like the hair braiders, but I remembered the good words of Dr. Martin Luther King that even though he's also a hair braider, said, "Don't see color, see cheese."
She is just, oh my goodness. I don't.
How I snitched my neighbor to the ice.
She is not sympathetic. That's the problem. The problem is we all saw, if you saw the Kyle Rittenhouse case, when he got up on the stand, I mean, you could see how much this affected him. She answered in a monotone. She didn't change her voice. Even when she said she was going to die, like pass away. I have had those stories. They are not easy to tell. You know, I don't open up with, you know, those kind of stories. And if I had to, there would be noticeable changes in both my tonality, my ability to look anyone in the eye or look at the jury. I would probably curl in on myself. As much as body, you know, language is kind of a vague science of witchcraft, it is also, there are things you can see with your eyes. Something about her kicks out my lizard brain and says, this is a predator, not a prey. I can't maybe put it into words like, you know, penny problem glasses yesterday, but I can verbalize it the way I can. And that there is not a prey. That is not a little Bambi running around. That is Shere Khan.
Yeah, she probably sold her media rights to the inmates for cheese. She is very corpus mentis, Brandon. She's not insane. Yeah, and she probably have a provision in there. She must be played by ScarJo because she's half Danish, and everyone wants a half Danish.
True.
Hey, Victoria. What's the wrong one? The state should rebuttal every part of the story. Let's wait and see what the state rebuts. But I think they will rebut. Yeah, they will rebut because her story doesn't add up.
Also, Baker, if someone on their first date, I don't know, breaks your cell phone, taps you on the temple, and threatens to be a very ungentlemanly person to your body, do you go on a second date with them?
That's how most of my dates starts. That's because I think that's a sign she really likes me. Isn't an option. No, that's the follow-up book.
Peter Jackson to do the movie. Baker's going to be like, oh my gosh, they're just going to be hiking in this.
Yeah.
The Fellowship of the Suitcase.
It's going to be a 45-hour long three-part trilogy just going to the suitcase or buying suitcase.
Thank you. State, are you intending on putting on a rebuttal case?
Yes, Your
You may proceed, sir.
Dr. Tanya Warren.
Dr. Tanya Warren. What is the jury looking at? It was the RO orders.
Yes. So when Sarah would get him arrested, or he would get arrested, she would get protective orders. Now there's conjecture between the family and him that she would lure him over to the house only to get him in trouble.
You swear or affirm the testimony you should give, shall be the truth, the whole truth, and nothing but the truth, so help you God. I do.
Dr. Kamala,
That'll
can you
be my
state and spell
memoir.
your name
I
for the
wish
record
I
first?
was the Bush.
Thank you. You may be seated.
Good morning, ma'am.
Good morning.
Where do you work?
I'm employed at Meridian Behavioral Health Care in Gainesville, Florida.
And what services do you render there?
I'm their chief medical officer.
And can you tell the jury what your educational background is?
Yes. So I graduated with an undergraduate degree at the University of South Florida in chemistry. I then attended medical school at American University of the Caribbean. I did a residency in psychiatry at Connecticut Valley Hospital in Connecticut under the auspices of Yale University. I then came back to Florida and did a fellowship 1 year in forensic psychiatry at the University of Florida.
And since your educational background, what have you been doing professionally?
Yes.
This is rebuttal. Rebuttal. Defense rested, so this is rebuttal. This is an expert who will now say everything Dr. Harper said is BS. You were all dumber for listening to that. Maybe
Yes,
she'll do it in a better way than Dr. Harper did it. This is the battle of the experts. Who do you believe more?
I will say, again, the state is allowed to bring experts to rebut the defenses. So let's see what she does. She does have a medical background rather than, a therapy background. And how will that, change her maybe observations? Will she be more clinical? I was not impressed with the test and lingering test that the other therapist did. So, did she get Sarah get those multiphasic, whatever the things we learned in Amber Heard to try to figure out what's going on there?
Yeah. Well, she said she was scoring low in the lying on the test score, not like Amber Heard, who had the highest test score ever seen. That indicated she was lying.
So I'm a licensed physician in Florida. I am board certified in general psychiatry and forensic psychiatry. I was initially employed on faculty at the University of Florida from 1998 through 2015. I retired there as the vice chairman of the Department of Psychiatry and the director of the Forensic Institute. I then went to work as the chief medical officer at Meridian Behavioral Health Care, which is a community mental health center.
Psychiatry?
So psychiatry is the treatment of mental health disorders.
And what is forensic psychiatry?
Forensic psychiatry is the interplay of psychiatry and the law. So anywhere where psychiatry intersects with legal issues.
What is the difference, if any, between a psychiatrist and a psychologist?
So a psychiatrist has gone to medical school, where a psychologist has not.
And as a licensed physician,
So that was a little dig for the one yesterday that she didn't have an MD.
are you able to prescribe medication?
Yes, I am.
In the course of practicing medicine as a psychiatrist, do psychiatrists prescribe medication?
Julie, the good thing for Brandon is his wife isn't a true crimer. It's only him. That's why he's in here all day telling us how. You know how Brandon is. He's sitting here saying, well, my wife. And when she gets home from work, who has the preheated funny bunny ear slippers for her? Who's saying, I feel a back rub coming up. It's back rub o'clock. That's Brandon.
To treat mental disorders.
Yes, we do.
And when did you begin your work as a forensic psychiatrist as opposed to working at the faculty at the University of Florida, or was that concurrent?
In 1996 in the state of Connecticut. While I was doing my training at Yale University, I testified for the first time as an expert witness in the state of Connecticut.
And over the course of your career, have you done forensic psychiatric evaluations?
I have.
Approximately how many?
Thousands of times.
And does this include on matters such as competence?
Yes, it does.
And does it, just explain briefly to the jury, what does that mean, legal competence?
So competence is, do they understand the legal process? Do they understand who the different players are in the courtroom, who's on their side, who's not on their side, what they're charged with, what the possible penalties are, what the possible plea options are.
And have you ever done any forensic evaluations about insanity?
I have. I've done sanity at the time of the crime, and also I've been appointed by the governor of the state of Florida to do sanity for execution.
And have you ever been involved in working as a forensic psychiatrist involved in the subject matter of battered spouse syndrome?
I have.
Can you describe your experience in that area for the jury?
I've been asked to do evaluations by the prosecution and defense several times with regards to, and it's come up in different cases, criminal cases with regards to intimate partner violence.
And does all violent episodes within a relationship result in something that we are describing as battered spouse syndrome?
No.
And I see there is a book in front of you. What book is in front of you?
Yes. So this is the Diagnostic Statistical Manual, and this is the 5th edition text revision, which is the most current edition.
Is battered spouse syndrome in there as a diagnosis?
No, it is not.
And
because her defense team dresses her. They dress her to look professional. Dress for the job you want, not the job you have. Isn't that the saying you go with?
Yes.
We see this in every case, and we always talk about it. And people always, why is the defendant dressed like this? The defendant has nothing to do with it. Sarah's clothes is provided by the defense team. That's why they had a motion earlier that they were allowed to bring clothes to the prison she could wear. The defense team chose, we are going to portray Sarah as a businesswoman. She's kind of wearing the same clothes that Karen Reed wore. And it's just to try and give the jury an impression that she is professional, because they're going to listen to it that she's an alcoholic, that she have no life. So it's it's kind of to make that cognitive
Dissonance.
Jamie. Yes.
Dissonance.
Yeah. So they are looking at it and say, but that professional-looking woman over there, she couldn't have been that crappy part. So she has nothing to do with it. She's not emulating her lawyer or anything. She is not choosing her clothes. Other cases, yes, where they're not in prison, they choose to dress like they do, but Sarah has no say in it.
Well, that and also the jury will, let's be real. If Sarah came in her prison blues and the shackles, you would make a judgment off of that. And Sarah does deserve to have a fair trial, to be judged on, this case and this case alone. And, she didn't get her hair and makeup, but she can always wear street clothes and present herself, in the best favorable light for herself.
Yeah. If I was Sarah, I would have dressed like her neighbor and rolled into the stand. Yeah, and I know Karen Reed was wearing her own clothes, but Karen Reed wasn't in prison. But it's a choice the defense have made that we want to portray our defendant in this way. We see it in a lot of cases where you have people who are up for stupid small crimes. They get a nice suit because it's a matter of perspective. If you see someone dressed in a nice suit or a nice dress or something, or take it away from this type, Ashley Benefield dressed like a little mouse, to make her look a little more intimidated, a little more victimized. We talked a lot about it in the Carly Gregg case. She was dressed like a mix between Mo when she was in Catholic school and Timo wash off of, I don't know. It was the weirdest clothes, but people in prison doesn't get to choose, but you will always try to present yourself as the best possible way in court, because it'll make the jury think, could that really be that person?
Where, if anywhere, does it fit into any of the categories within the DSM-5 TR?
It would come under one of the trauma categories, most specifically under most likely post-traumatic stress disorder.
Can you describe for the jury what post-traumatic stress disorder is?
So this is a disorder that's recognized under the DSM for individuals who have suffered a traumatic event, and then they have re-experiencing of the traumatic event. They have different symptoms besides re-experiencing, such as hyperarousal, and also avoidance of triggers or symptoms, things that would
I'm hyper-aroused.
Are there any agreed upon criteria within the relevant forensic psychiatric and forensic psychological communities about battered spouse syndrome?
There are.
And what would those be?
So it's again, having experienced a trauma, repeatedly, violence within an intimate relationship, and then having symptoms secondary to that, avoidance, so tiptoeing around, trying to avoid recreating the violence.
And if a person experiences an environmental stimuli, something happens to them, another person does or says something to them, is their subjective reaction what is defined as whether there's trauma present or not?
I'm not sure I understand the question.
Let me rephrase it.
You can rephrase.
Cause for speculation.
You described there's a difference between experiencing a violent relationship and whether or not that person is going to experience trauma from those behaviors they witness and experience. Is that fair?
Yes.
Now I've lost my train of thought. Is it fair to say that an experience that a person has, whether or not that person believes it's traumatic, is a subjective experience?
Yes, each individual is different, and so each individual is going to take that experience differently.
Can hypothetically a couple be involved in a violent relationship for a number of years, even 3.5 years, and battered spouse syndrome not necessarily apply to either or both of them?
Yes, that's correct.
Can you explain that?
So again, each individual is different. So one individual may develop the symptoms of battered spouse syndrome, and one individual may not under the same exact circumstances, just depending on their makeup and what they've experienced in their background and their biological makeup.
And is there a cycle of violence that is sometimes used to describe battered spouse syndrome?
There is.
Can you describe that?
So there's the initial, there's kind of a tension buildup section where you feel the kind of tension building up, and the individual can feel kind of the incident coming, and then there's the actual incident of violence. And then following the incident of violence, there's a honeymoon phase, what they call the honeymoon phase, and that's the third phase, where the individual who created the violence attempts to make up to the victim and recreate kind of the relationship and pull them back in. And then it starts all over again, where you feel the kind of tension start building up again to the incidents of violence.
Does abuse have to come in the form of physical or sexual violence?
No.
Can you explain your answer?
So it can also come in ways of coercion. It can come in ways of control, such as financial. So if an individual controls another individual financially, or controls their ability to drive or go out, their ability to be around their other family members or friends, kind of isolates them from other individuals, controls their ability to work.
Yes.
So controls their ability to make money or access the funds. So they can control them in any number of ways.
Is this kind of about like an inequitable power dynamic in the relationship?
Yes, absolutely.
Can a man be on the receiving end of emotional or physical or sexual trauma and potentially experience, strike that. Can a man be on the receiving end of verbal, harsh words, physical violence, or sexual violence, and end up having the syndrome of battered spouse syndrome?
Yes, it crosses all boundaries, and we see it in all types of relationships, whether it be heterosexual or homosexual relationships. We see it cross all boundaries.
Don't run a phone battery
Can
down
this
there.
element of control come from controlling personal items such as identification papers?
Yes, absolutely.
Can control potentially, hypothetically, come from partner A gifting partner B an item, but still considering that item partner A's because he or she paid for it, even though it was a gift?
Yes.
And in this particular case, were you asked to do an evaluation of Sarah Boone?
Yes,
Do you see Ms. Boone in the courtroom today?
I do.
Can you point out where she is and what she's wearing?
She's sitting at a table there, wearing a dark suit and a pinkish top.
Did record reflections identify the defendant?
Record will reflect.
What date did you have an evaluation of Ms. Boone?
It was early in October, I believe October 2nd.
And this was at the request of the state of Florida
Yes, it was.
and subject to a court order?
Yes,
And who was present for this evaluation?
the defense and the prosecution.
All right. Tell us about the evaluation with Ms. Boone. What do you do first?
So I met with Ms. Boone at the jail in a conference room. Again, the prosecution was there and her.
Also, are we not conflating what the bar titles and what the medical board titles something? Dirty tactics.
Well,
What?
so I think they have to go over what her credentials are. And I don't put much stock into the board certified versus, practicing. What I do put into perspective with this doctor is that she does have a medical degree. So she is going to have a much better understanding of what happens in the body when it is constantly pickled with booze. So she's going to have a much greater insight probably into what is it? What is the new word that we're supposed to say instead of booze hound?
Alcohol disorder.
Alcohol
Abuse of
disorders.
Abusive
Okay.
alcohol abuse disorder. Something
So
like
I
that.
think that she's going to have a greater insight as to what that impact will have, that constant, state of inebriation. And I think that's going to be very telling. I don't know. That's just my 2 cents, is that that's what she's going to bring to the table.
Yeah, and I know the jury wouldn't notice that, but I like that he was the only one who had both sides present for her evaluation, because defense wasn't present for the defense evaluation of Sarah. But I know they won't catch that one. And the medical board could call the same thing Y, and it wouldn't be on the book. You have a bunch of attorneys that say you can have a defense X, and yeah, but you know how it is. Who can sell sand in Sahara? That's what the experts is doing this for.
Attorney. I met with her for
Alcohol use disorder.
approximately 2.5 hours, just under 2.5 hours. I introduced myself and explained that the interview would not be confidential, that I would be coming to court if asked to share my opinions. And she agreed to participate. I then start out with just general information, so getting to know her, date of birth, kind of background information, who her parents are, childhood. I go through her educational background, work background, her marital background. I go through health, psychiatric background, any substance use issues. I do a mental status examination.
Stop you there.
Yeah.
Elaborate further on that.
So a mental status examination is just questions to determine kind of memory and cognition, kind of how their thought process is, how they're thinking. Are they able to kind of fluidly think through processes?
All right, go on after that.
And then I transitioned from there into walking through the incident that happened with her.
All right, what did she indicate occurred on February 23rd, 2020 to you?
Is it all right if I refer to my notes? Just
if you need them to refresh your memory, please do so, but don't read from them. Just let us know.
So she had a difficult time recalling what time they actually woke up that day. Initially, she said in the morning, and then she said she wasn't even sure that it was in the morning. She said that they both wanted to drink, but that she asked that they could clean the house first instead, and that they did some vacuuming and cleaning. They had a half a bottle of wine left over from the day before that they drank. She felt about 4 o'clock in the afternoon. They drank that out on the back porch. And she described that they had kind of 2 beach chairs out there and a dartboard, and that they kind of hung out there a lot on the back porch, spent time out there. They did a puzzle out there and completed that, and then did some kind of artwork. She felt like he was getting
Volpe, you just said it, and now she has the and the lip smack.
Frustrated thinking about his life, that he had lost his job. And so she encouraged him to call his daughters, although she knew that that they did not like to talk to him when he was drinking. So I'm not sure why she had encouraged him to call them at that point.
That's a really good point. And again, I think this doctor will bring up all of those things where that's the wrong behavior to have if you're so concerned and you want to help him. You're forcing him into the laws after the laws after the laws to keep him downtrodden.
And this is a perfect example of poking that wound that they know. A person is going to know your weaknesses, and they're going to poke at them like, hey, you should probably call your daughters. You're a terrible father. Already setting him up for failure. This, again, there are these constant little digs, and George will take it. Or even she, they'll go back and forth, and they'll take it until they, drink enough that they lose it, and they both start saying some really hurtful, disgusting things, I'm sure, to each other, and it gets out of hand. But I don't see George saying all these things. She has all of this evidence. I'm sure he did lay hands on her, but that video with the TV, yeah, that's a no-go.
Only one time, because she's a state, she's not allowed to visit her more.
Because they were already drinking. And she also at some point encouraged him to call his brother because she wanted him to explain to his brother that he had pulled her down the stairs the night before, although that didn't happen. He didn't explain that to the brother, and according to her. And then at some point they went and got another bottle of wine and some cigarettes from the grocery store and continued to drink. And then they were inside the house, and then he, I guess, tagged her at some point and said, "Tag, you're it," which indicated that they were going to play hide and seek. And she said she went upstairs and hid in the shower and waited for him to come, and he never came upstairs. Excuse me. And so she eventually came out of the shower to look for him. And as she was coming down the stairs, she said she saw him slipping into a suitcase, which was on the living room floor, that they had put out because they were going to donate it. And sorry. And so she went downstairs and indicated that she had found him, and they were kind of laughing. And she zipped the suitcase up And they continued to laugh, she said, at that point. And they were having a good time and laughing and enjoying themselves and having a good time. And she said, and then she became angry. And she said she remembered what it felt like when he was choking her. And she became angry.
What did she do after she became angry?
It was not tag, it was hide and seek. Why can't people trust Sarah?
I'm going to refer to my notes at this point.
If you refresh your memory, just
Yes.
go down and then tell us what you remember.
Oh, to be a fly on the wall when she's in with Sarah. Like, I volunteer as tribute.
She said that she shook the suitcase and that she lost control of it and it flipped.
And then what happened?
Then she said that he stuck 2 fingers out
We haven't heard
and
it.
her son's baseball bat was sitting there and she picked the bat up and hit his hand.
I know, but they had prison rules, hide and seek. I don't understand the tag rate either, but it's prison rules, hide and seek. It's the new thing. You'll all be playing it next year with your spouses. So, suitcase up.
So, yeah, I mean, having 3 young feral boys, everything kind of becomes a combat sport. So I call it combat hide and seek or combat tag because it usually just ends up in WWE moves. So that's what was happening.
Yeah, it's what's happening when you have boys.
Yes.
Both my brothers made me get stitches in my head because they threw me into something.
Then what happened?
And then she went upstairs and waited for him to come upstairs.
All right. Alcohol. Can you tell us what you know about the effects as a medical doctor of ethanol or alcohol on the human body?
Yes. So it causes intoxication, as we all know, and it causes disinhibition. It works on the frontal lobe of the brain and allows us to do things that we wouldn't normally do. It disinhibits us.
And in the course of your practice, have you ever come across a diagnosis of alcohol abuse disorder?
Yes.
And what is that?
Well, alcohol abuse is an old disorder. So we used to use alcohol dependence and alcohol abuse. It's now been combined in the DSM-5. In the DSM-5 TR, it's alcohol use disorder.
In considering what a patient or a client or somebody that you've been asked to evaluate by a government entity, do you take into account that person who's relaying the history to you's consumption of alcohol at the time of the history that they're giving?
Yes.
Why is that?
Because again, it affects their behavior and their actions.
Does alcohol have any effect on a person's memory?
It can.
What, if any, relationship is there between acute alcohol use or acute alcohol intoxication and battered spouse syndrome?
It can affect your memory. It can affect your reactions. It can affect your response to different things.
Does the disinhibitory nature of alcohol strengthen, weaken, or have no effect on battered spouse syndrome?
It would depend on each individual again.
Generally speaking, it is important as an evaluator to get as much information as possible for rendering an opinion, such as diagnosing somebody with something out of the DSM-5 TR or battered spouse syndrome.
Yes.
In this particular case, did you require any additional information to reach your conclusion about the relationship between battered spouse syndrome and the events of this evening?
I based my opinion on the information that I had. Certainly, if there was more information, my opinion would be subject to change.
And what was your opinion?
My opinion was that she did not give me enough information to diagnose her with post-traumatic stress disorder at the time that I evaluated her at the jail.
And specifically talking about it.
Yes.
She seems, we might be up to 2 point. Are we up to 2? She seems more jittery today.
Well, we were at 1.2. Does she have a no, it's just her hair. It looked like the bald spot.
I mean, it does look a little thinner there, but it also could be the glare. So,
Yeah.
and Marie Moss, I didn't hear the objection, but sometimes lawyers will object to try to break up the flow again, get the other lawyer on to stay on their toes. Sometimes it does break their kind of attention, so you're not supposed to technically object when there's nothing objectionable, but it does, can break up a flow or things like that, or kind of get the lawyer to stumble.
Yeah, and because this isn't good evidence that she was a massive alcoholic, and that her brain would have had certain problems at that time because she was an alcoholic. Because again, remember, Sarah remembers everything except those 9 minutes between the two videos, because she was very corpus mentis. She didn't drink, she don't drink, she won't drink. I swear on my kid's life, I won't drink. Which she said when she was so hungover that she didn't understand she was being interrogated. He objected to the doctor saying Sarah did not give enough information for PTSD. Oh, thank you. It's not clear. I think it's hard to tell. But she's looking disheveled today.
I feel weird staring deeply into Sarah's scalp.
Yeah, it's not that hair.
Things that were not on my bingo list this year. Stare deeply at Sarah Boone's scalp.
Her clam, on the other hand.
Well, she straddles some hedges. I am there with bells on, like National Geographic with David Attenborough. Here's the local booze hound in its local habitat. She gracefully, on unsteady legs, straddles the hedgerow, and she's going to get some water. I just need David Attenborough to completely do an voiceover of the Sarah Boone hedge straddle.
I left a comment yesterday on the channel replay about psychologists. They study human behavior in order to manipulate it. Your TV is the psychological tool of governments. Even supermarkets use them. Well, I used to run the frost department in a supermarket. Nothing worse than those. Buy Timotex, the best cleaning tool you can have. It'll clean your house with no water at all. Listening to that for an 8-hour shift, I will never buy Timotex. Or it's Christmas. Get ready for Christmas by buying the butcher's favorite pork roast. It's the best pork roast ever. Well, we're not having pork roast now.
I can't listen to Christmas carols because I have been subjected to every single band that thinks they need to do All I Want for Christmas and Mariah Carey in retail. I am just done. I am so done.
The alcoholic human is thirsty and so has to use her remarkably thin alky legs to straddle the bush to take a fresh drink. When we see her wobbly legs, she reminds us of a newborn baby giraffe. Unsteady, wobbly, but the newborn giraffe will be able to run in 5 minutes. Sarah will probably have to sit down. Brenda, yeah, but it's for this experts to put that in the head of the jury.
Yeah. Don't remind me it's almost Mariah Carey season. I have macro trauma because of Mariah Carey.
Thank you so much for your patience. I have a matter I have to discuss with counsel outside of y'all's presence. It may take a little bit more time than just our conference up here, and we don't want to have y'all just hanging out waiting for us to figure out what we're going to do next. So I appreciate your patience. We're going to excuse you to the deliberation room at this time. Please do not conduct any independent investigation or research as to the person, places, things, or charge involved, and do not have any conversations amongst yourselves or anyone else about those things, and we'll bring you back in as promptly as possible. Thank you.
No, the worst song is
Y'all can be seated.
Do they know it? Christmas
Throwing, if you can find me that
time
portion
at
of the transcript that we were addressing as to
Yeah, that is pretty bad.
additional opinions and other depositions and anything in Dr. Warner's deposition that you believe we need to address regarding this opinion as it relates to PTSD.
Well, Judge, it applied to every opinion she was going to express. It started on page 37, line 24. As it relates to Sarah Boone, do you have any diagnosis as it relates to her? And then 38 is when she started talking about a generalized anxiety disorder, and that she was not for sure whether Sarah Boone had a generalized anxiety disorder versus if it was just an adjustment disorder to being in jail. Mm-hmm. And then she also mentioned in that same answer that Sarah Boone had some narcissistic personality traits, and that those were my two major diagnoses. And then I questioned her further about that. She explained again on line 17 about general anxiety disorder versus the adjustment disorder. And I hadn't had time to fully formulate that opinion out. Line 21, I need time to go through my notes and think about it and process it.
Page. We're still on page 38.
38, line 21. I need time to go through my notes, think about it, process it. But I had other depositions, as you were aware yesterday, so I had to prepare for those and go through that. So I have not had time to process all my notes. And I said on line 39, well, doctor, I'm trying not to inconvenience you. You know, we're set for trial October 7th for jury selection. Line 6, I anticipate your testimony would be until a little later. So we could discontinue the deposition and then reset it when you've got time to review. Because obviously I'm not going to want to take your deposition and you have other opinions that are not going to be covered. And then I asked.
So this is all because Owens is unprepared.
He said conducting discovery after the jury.
No, it seems like she hadn't formed her opinion when he did the deposition. And maybe they're touching on something that she formed an opinion on later.
Okay, that makes more sense. I was just trying to.
You're in the house of Elron, and it's 10 o'clock in the morning on October the 24th, if you want to know. Elron, that's the guy from Lord of the Rings.
And Mr. Smith, I think. Agent Smith.
Oh.
Jury trial starts is completely unacceptable to me. So that's my position. If she needs to issue a supplemental report, or if there has become a need for a second deposition, then we can address that. But it would be my position that we need to get this done because the state doesn't have any appellate rights once jury is sworn and jeopardy attaches. And I say on line 23 of page 39, well, you obviously understand my position. I'd like to finish the deposition today as well. But if she is holding out that she may have other opinions and other diagnoses after she has had more time to think, review the paperwork, then obviously that creates an issue. And then she said,
yes, this is a rebuttal, as you can see in the bottom. We have the state's rebuttal witness for Dr. Harper, who has a totally different opinion of what symptoms Sarah was showing. But now the defense is claiming that she's going to testify to something they didn't know about. But let's see how it goes.
but if that happens, I can bring that forward. And then you can add to your deposition at that point if my opinions change after having reviewed further. And I refer to Mr. J. Page 9 of 40, Mr. J says, I think we plow ahead. This is our time with her. Court reporter's prepared to give us a transcript by the end of the week. Something needs to be amended.
End of the weekend.
End of the weekend. If something needs to be amended, then she can A, issue a report. B, if we need to take a deposition, an abbreviated deposition on the limited subject matter she is not prepared to testify about on today, then we can do that. But the notion of halting a deposition today that is set for 3 hours and then doing a 3-hour deposition during trial, especially after jeopardy is attached, is not what the state would do. Then I respond on page 40, line 23. I'm not suggesting that, Mr. J. I'm suggesting what you just said at the very beginning, which is let's finish. But if she has some supplement, then I would want to take a brief second deposition as it relates to any new diagnosis or opinions. Mr. J responds on line 4. Okay. What I'm understanding her to say is right now, there has been a previous diagnosis of an adjustment disorder in some of the records, and she just needs to review her records to see if she thinks that is the best diagnosis that she would give as opposed to a generalized anxiety disorder. And then the witness says, you essentially flipped that, Mr. J, upside down. You got that backwards. So we go on to page 42. Line 1, Mr. Owens, I agree. And Dr. Warner, just let the state attorney know.
Yeah, but we're skipping a massive portion of 41
Okay.
that addresses specifically opinions
Let me go back.
as it relates to generalized anxiety disorder.
Okay, the witness starts on line 15.
We're skipping pages?
So she's saying she has the generalized anxiety disorder, and I'm saying I want to review it more. Because Sarah Boone had disclosed to the doctor that she had been previously diagnosed with a generalized anxiety disorder. And so the Dr. Werner was considering that admission. But she was saying, I want to review it more to see if I think it's more of an adjustment disorder to being in jail, Judge, to being in the correctional setting right now. And that the stressors that she is under right now as opposed to a generalized anxiety disorder. So Mr. J says on line 22, okay, so on this topic, if something new comes up, then we can address it. But if you have other topics to dispose her on, then I suggest we go on. And then page 42, line 1, that's when I say, I agree. And Dr. Warner, just let the state attorney know. I know that you may be, we are on short time. If you do review your notes over the weekend or whatnot, and formulate any other opinions, just let the state attorney know, and I will address it.
We'll address it.
And we'll address it. Line 7, the witness, Dr. Warner says absolutely. And then, do you want me to continue reading or?
If there's portions you want to highlight for me, I mean, I have the transcript. I'm following along with you.
That was the general understanding that we had about all diagnoses, all opinions that she may have. And so she starts talking about the mental status exam that she gave her, and then she page 43, line A, she said narcissist. She said she
When I read the divorce letters, you'll find out.
has narcissistic personality disorder traits. Or I asked that question. That's how she answered. She goes through a little bit of that. And then, paraphrasing, she talks about the grandiose component of criteria that she met. And then on page 45, I asked her what other criteria, on line 1, would tend to indicate that she was a narcissist. And the answer by Dr. Warner, I didn't say that she was. I said that she has narcissistic traits. And that was the examples.
Excuse me for interrupting, but can we lasso this back in?
I understand that's what the depo reflects, but the non-objection which led to objection pertains to an opinion specifically about post-traumatic stress disorder. At this time, no opinion is being referenced, nor does the call of the question pertain to narcissistic personality traits or a diagnosis of narcissism. The question pertains to PTSD.
All right, page 46. Line 1.
Danny T says, it's Potty Mouth Sue's birthday today. Happy birthday, Sue. Use all the C words, the F words you want today. It's free. You don't have to contribute to the swear jar, but you just can't do it in chat. Well, not my chat.
Question, okay. Do you feel like she suffers from post-traumatic stress disorder? Line 3, answer. She didn't give me criteria with regards to that. She discussed having fear and anxiety of his family and fear that they would come into the jail or have someone else come into the jail and harm her. She talked about that. And she spoke about, having recollections, remembering abuse from George during the evaluation. Question 13, 113, 146. But you don't believe that she suffers from post-traumatic stress disorder, in your opinion? Answer, line 15, no. I would have to look back through my notes to see if she fully met the criteria. Question, line 17, can you explain why you don't think she suffers from post-traumatic stress disorder? Answer, line 19, no. I didn't say one way or the other. I would have to look back through my notes for that. Line 21, question, is that something that you may, in the future, give an opinion about after some time reflecting and reviewing your notes? Line 24, answer, I may. Number 25, question, okay, and that's something you will let the lawyers know about if that changes? Answer, line 2 of page 47, yes. That's specific to the post-traumatic stress disorder.
Okay.
Why do I have a feeling like a sandal is going to go flying from the expert So
So what's the legal
she's
objection?
giving him the Chungla look.
What are the legal grounds of the objection?
I would not take that deposition, Judge. When she said, I have not had time sufficiently to answer these questions, these diagnoses, these opinions, if this wasn't set for a definitive date that you had already told me it's not going to be continued, I would refuse to take that deposition. But under the promises from the state,
What
I
are the
will be
legal,
notified of
what are the
any
legal grounds of your objection? I'm familiar with the background. I'm familiar with the time frame. I'm familiar with all the dates and the depots and the coordination
Browns
and
is
everything
getting
we had to do to get this all
Please don't ask me about the legal. Just remind. I'm just going to moan a little bit more, and please believe me.
teed up before trial. What are the legal grounds of your objection?
It's not fair.
I understand the backdrop.
I mean, I don't know if there's a legal ground other than we had an agreement as attorneys, as parties, that I would be notified of change of opinion and I would be allowed to take a second deposition. That's the only thing I know to object to.
Oh, they think he
because I was not given that
promised.
opportunity, which was an agreement between the parties.
Mr. J.
Judge, I don't appreciate the implications that they're making. What I would proffer with this witness is, we spoke yesterday. I asked her if she had any change in her opinion about any of the diagnoses. She said no. And I asked, well, then my position, my understanding of her position is that it doesn't matter whether she had PTSD or not, because what Ms. Boone said at the time was that she zipped Mr. Torres up into the suitcase. They were both laughing. And once he was already secured in the suitcase, she became angry and then did all the things that she did. My expected,
Because his case is unraveling in front of him. He's
answers from the doctor based on a very brief conversation yesterday and this morning was that if I asked her whether or not PTSD or BSS had anything to do with this particular case, that her answer would be, it doesn't matter because of what she stated happened. I'm not asking her about her diagnosis of PTSD. I'm not going to be going into narcissism. I'm not going to go into whether or not she ever delineated the difference between adjustment disorder or anxiety, because my understanding of what she told me was that none of this matters. None of this matters because of what she said to us during the evaluation.
But the question was, and I may have to ask Madam Court Reporter to read it back, but my memory of what the question was is, have you formulated an opinion with regard to PTSD?
And my expected answer was, it doesn't matter because of what she said during the evaluation.
Okay. Unfortunately, that was not the answer that came from the witness. The answer was a definitive no.
Attorney's.
I'm not casting blame. I'm just going back over what was asked and what was said. Okay.
Yes, Judge, and that's his position, that post-traumatic stress disorder, that doesn't apply in this case, and that he, I'm sure, reflected his opinion to the expert. But that doesn't mean that that's my opinion, that post-traumatic stress does not apply.
That's irrelevant for the purposes of this argument.
Well, their discussions and him feeling like it didn't apply.
Okay. As an officer of the court, he just told me he
Thank
spoke to
you,
the expert
Unhung
yesterday and the
Hero.
opinions haven't changed.
Thank you, Unhung Hero. Objection. This is detrimental to my case.
Doggone it. Trying to make me do all legally stuff like a real lawyer. This is unfair.
Here's a tip for watching lawyers. When the facts are on the side, they pound the facts. When the law is on the side, they pound the law. When the neither is on the side, they pound the tablets. Exactly.
And the opinion that was offered at the deposition was, I'm not sure. And based on what he had proffered as to what he expected the answer to be, the answer was not, it was not going to be any different. It's not applicable. It doesn't matter because of what she told me. That's unfortunately not the answer that was given. So what is it that you're asking me to do at this time, Mr. Owens?
I'm asking, I don't know if we need to proffer the entire testimony of this witness, because opinions and diagnoses have apparently changed. I think I have a right to take a second deposition before she testifies.
What other opinions, Mr. J, if any, are going to be offered by Dr. Warner?
May I just proffer?
Yes.
All right, you've been present for all this hearing, yes, doctor?
Yes.
Am I misrepresenting any of our conversations?
No.
All right. And so if I ask you if battered spouse syndrome or PTSD has any relationship to the facts of the case as the defendant relayed them to you, what would be your answer?
That it's not related to the incident as she reported it.
Okay. And if I ask you, therefore, if there are any prior instances of violence, would that change your opinion? What would your answer be?
No.
And if you reviewed any other materials, would that change your opinion based on what she told you about what happened that evening?
No.
All right, that's it.
Judge, number one, she's given a legal opinion. Number two, it's a discovery violation.
What is the legal opinion?
That post-traumatic stress disorder doesn't apply in this case.
Dr. Harper testified it did, and that's what experts do.
I would like to have known that, and that was.
You're such an idiot.
He was at the deposition, so Special K.
Yeah, but she didn't formulate an opinion at that point. So, but now he's going to turn that into a Brady violation that she didn't believe that PTSD had anything to do with the case.
So
But
basically what Owens is saying is that it was unfair that she hadn't formulated a full and complete opinion when they did the deposition.
Yeah, because now she
of
says,
that,
I have now reviewed it and I don't feel. So that's a Brady violation that even though she didn't tell the state that she had that opinion, it's a Brady violation. And PTSD is a prerequisite for battered spouse. Yes. And according to his own expert, PTSD had something to do with it. That was a legal opinion that he then let them have.
and she's a forensic psychologist, so isn't she qualified to give legal opinions? I mean, isn't that why we have all these experts that go in and say, I've studied the law in conjunction with psychiatry, and so I am, qualified. I understand the statutes, and I have authority to, say all of the things based on law because it's forensic. I mean, am I confused?
I think he's more confused because he has nothing to come back with. Adding to the swear jar because I feel like it's going to be needed. Yes.
Baker's coming back to Dollywood on this swear jar tour.
The transcript he's reading is what the doctor has testified to. I'm confused. That's the profile they had of her before. And now today she has an opinion that she hasn't disclosed to the state, that PTSD wasn't a factor. And that's what she's going to testify to today. But he's now claiming it's a Brady violation, even though the state didn't know she had that opinion. Which it can't be, because they can't turn over evidence they don't have.
Judge Kranick, please make this, I'm smelling burnt toast. Make this go away.
Yeah.
I will say we could not have had a better judge to deal with Owen's shenanigans and all of these delay tactics, because he really does get to the heart of the matter. Like, okay, what is the legal thing? And he's not cross. He's not, cutting off the defense so they can use it in an appeal. They are,
And again, they can just impeach her with the prior statements during the cross-examination. You're correct.
Or say our doctor diagnosed Sarah with, PTSD and the big SAD and all the other stuff.
Yeah.
That's not a change in testimony.
Where is that a change in the deposition?
Read the whole transcript. I asked.
No. This is a 87-page transcript. You're objecting. You have the burden to establish your objection.
Give me a minute. I'll read through it and find where I asked her.
I mean, this isn't the first time I've looked at this deposition. The state provided it to me when we had the hearing on whether or not battered spouse would be permitted. And the state provided specific highlights for me to look at. At no point in time did the defense say, look at this, look at this, look at this, in her deposition when we had that hearing. So other than what's being provided to me right now and what's been testified to this morning, I don't know what opinions she has. All I know in coming into today is what the basis of her opinion was, specifically with regard to any of the statements that Ms. Boone had provided, which was the whole crux of the state's motion to prevent battered spouse from coming into evidence.
Judge, if you look at page 66, line 20. Let me know when you're there, Judge.
Hang on. Yes, sir.
Page 66, line 20, question. Okay, so other than the couple of hours that you intend to maybe reflect on your notes and anything else, any other work that you intend to do on this case? Answer 23, no, sir. Not that I'm aware of. Line 24, question. And you've expressed all your opinions, at least generally, here today. Answer, page 67, line 1, yes, sir. Question. Then I go into these. Then on 67, line 7, question. Just double dog sure. You admit that you have no other opinions other than the ones you've expressed here today.
Double dog?
Line 10, answer. That I've been asked about. If I'm asked something else, that I'll offer it. Number 12, question. And you've been provided all the resources you need to rely on and express your opinions. Line 14, answer. I have based an opinion on the resources that I've been provided. If there's other things out there to be provided that may or may not change my opinion.
If there's other out there, it
I
may or
believe it's a
may not
discovery
change my
violation because I
opinion.
should have been notified that there was going to be a change in opinions here today. And we had an agreement that I was going to be allowed to retake the deposition and not be ambushed in the middle of the trial with a new opinion.
What
Sir, you have
new
done nothing but
opinions
try to ambush the
are
state.
different based on what Mr. J proffered the testimony is going to be?
I have to ask Madam Clerk to reread the question and the answer from the expert since a long time.
Madam Clerk, or Madam Court, were you able to reread the portion of the proffer as to what Mr. J asked of the witness? Absolutely.
How many dogs must you swear on, MG, before it's 100% appeal proof? It's this is the most important question of the day. And what size dog must it be before it's legally proof?
Do they have a standard like I double dog dare you, I triple dog dare you, I quadruple dog dare you? Because there is an etiquette, and I need a further investigation now.
Yeah, but if you're swearing on a Great Dane or a Chihuahua, there's a big difference in those
True.
two.
I don't think a swear on a dachshund would be as good as a swear on a Great Dane. Is that sizest? I don't know.
Maybe we should all swear on not Dobermans, those weirdo dogs they use in the Alps with the whiskey bottle.
Oh, the Bernese Mountain Dog?
Yeah, because they help people.
And they carry ale or brandy. I can't remember which, but
Brandy. Saint
a
Bernard.
dog
yes.
that brings me booze, I am here for it. For I would only dumpster dive.
Can't argue with that.
You can tell Judge Browser Justice is getting ticked off by this.
Yeah. Jose bias 2.0.
I do think we're going to get will someone think of the daggone jury? We have been here, and every single time we get something going, you want to delay, you want to do over. I'm getting tired of it. I'm waiting for a pregnant pause. Part 2. With Charlie Sheen
Court can
back
step
in
off for a moment
action.
while Madam Court Reporter is able to provide that reading.
Well, we're caught up again because court had to step off while Madam Court Reporter found the papers. So he's now being ambushed because she will say, yeah, PTSD had nothing to do with it. And it wouldn't change my mind that she claims she has PTSD. And even knowing about prior bad acts wouldn't change my mind. That is a lie. It's obfuscation. It's at least a three dog not daring testimony.
It does seem a little, again, what was stopping him from, contacting this expert and saying, now I don't know what the protocol is as far as it being a state's expert, but just, checking up with the state. Hey, has she, gone on has she come up with any more concrete diagnoses? Does she have any other opinions? But his own witness said it.
Yeah. Yeah, that wasn't a legal representation yesterday when she said, yeah, clearly it's PTSD that made her do it. But today, it's saying someone didn't do it because of PTSD is a legal opinion. The problem is, and I know some people out there love this guy. He's the best lawyer ever, and he's fighting for an innocent woman. The problem is he's woefully underprepared. Talking about his media deal this morning, if there's any truth to that, he just saw an opportunity to get in here, get the payday, and be famous. I said it when we heard his first testimony about how he saw it on social media, on the YouTube. He was in it to be the next Emily D. Baker. and I feel more and more vindicated. People who believe this guy is an effective defense attorney might be a little blinded by we just took a position that no one else had, and now we have to fight for it. Because he has never been prepared. Yesterday, I know someone said, well, he's running hoops around the state. No. He just had the judge yell at him. What is the legal position? It's more like a feeling. More like a feeling.
This seems like a desperate tactic to delay. And it doesn't, the fact that he could not articulate a legal theory by which this was bad and decided to, question the ethical nature of the state. I don't know if that was a smokescreen because he has his own ethical issues right now.
They are on rebuttal, Iris. I put it in the Chiron so everyone doesn't have to ask every time. But there was an objection because the shrink for the state said, nope, no PTSD in this one. Owens got mad and said, Brady violation, because you didn't disclose to us that that was your finding, because in the proffer they had with her, she said, I'll have to think more about it. And now he claims that the state knew she had that opinion, and the state said, I didn't. She said, I didn't tell the state. And again, the only thing she's going to witness is she won't change her mind. It has nothing to do with PTSD, no matter if there was prior acts of violence. I know he's fighting for his defendant. That's his job. And she should get the best possible defense, but this isn't it. Because he can't cite case law. He can't cite any legal reason why he is objecting. It's just that, well, she said something on page 5. And then she said something on page 88. Well, what about the pages between that? And now he want to have another hearing to hear what she's going to say. And she just said, I'm going to say this. You don't need to go back and push at her. It's desperation because his expert did so poorly yesterday. Iris.
And he's so angry. So John Gary made a good point that Owens sometimes plays dumb or try to sneak things in by kind of being confused, but it doesn't come off as kind of befuddled and well-intentioned. He gets snippy with the judge. And if we've learned anything from, being law tube adjacent lay tubers, it is
wine moms, please. Wine moms.
I'm a lay tuber. I like the single entendre. Look, I'm not going to do OnlyFans. I can at least tell my mom I'm doing lay tubing, and she'll be like, the hell? But it's so grating and aggressive. He's so aggressive to the judge. I thought the first rule was to not piss off the judge. I could be wrong.
Yeah. Has Owen checked that he didn't receive the revised opinion? Well, there is no revised opinion. This is the first time she ever stated that opinion. That's why it can't be a Brady violation, because the state didn't know she was going to say that. Because this morning he did not know about the motion because he had not read his email. Who have time to read emails? It's not like we live in a digital age and we use emails all the time. I saw they had a Soroyakti also now, a hideous sour concoction made from the rum, black tea, and Strorum is only good if it's 160%. Well, 106 APV or whatever you call it in America, 80%. It tastes kind of like you had mouth sex with an exhaust pipe on an old truck. But
so better or worse than Malort? I think that's kind of where I need to, like, are they both going to make me regret all life decisions prior to that?
I don't mind Malort that much. I'm getting used to it. It's just the aftertaste I don't like so much.
Yeah, it tastes. It sticks with you for years. I have
Yeah, that's why you have Dr. Pepper.
I have current dramatic stress because of Malort.
It's not a microaggressor in my world. But they use it in, especially if you go skiing in the Alps, they put it in the tea
Oh,
to heat up the blood.
have they not
So
heard of Kahlua and hot chocolate or Bailey's and hot chocolate?
I like hot chocolate and a brandy or cognac. That's good.
I have not had cognac. I'm graduating to box wine this time because like just a spigot on the side of the desk and I'll just go because you know
Well, that's because you're hanging out with me. I'm wine mom. I wine mom, so I'm rubbing
hey,
off on you.
it's wine o'clock somewhere. We just need a live, laugh, love sign somewhere and we will have it figured out.
Who does my research? I don't do research. I have two wonderful ladies, Marissa and Jemima, who will yell at me incessantly over Discord that they have found new evidence and why aren't you streaming it yet? And I'm saying, it's 4 o'clock, I'm sleeping. No, you're fat and lazy, get out of bed. That's my research. And then Jamie hired them. That's how Jamie runs the company. A lot of yelling and me working.
Yeah, we have lovely, lovely people that can get us court documents. Jedi, Jess, and Marissa, they are always on top of it. They help me out because I stink out loud at getting documents. I'm like, where am I supposed to put the forum with the thingy and the www. What?
I was taught to snow ski from a Manhattan Cougar and Hunter Mountain. I was 16, she was 110. She was probably 40, but when you're 16, everyone's 110. You lazy bum.
I have never been skiing, but given my tenuous relationship with walking gravity, I don't know that's putting on a long piece of wood on my feet. It's going to help my coordination.
My sister lives in Switzerland, and she has a chalet in well, not a chalet, it's just an apartment, but they call it that because that sounds fancy. She has an apartment right next to L'Alpe d'Huez, which is a very famous mountain in France. And the
Ooh.
first time she said, "Oh, when are you coming down visiting?" I said, "July, when the Tour de France is going up the mountain. I might swing by." Yeah, but the other brothers coming down skiing. Said, if I wanted to be somewhere where I get wet and cold, I was just staying with my ex-wife.
We do have this one guy. So I don't mean to laugh at him, but he has land cross country skis. They're like these long paddles with a little bit of wheels, and he's got these sticks, and he just looks. I would film it, but I feel bad. But it's awful awkward. Oh, he's smiling. He must have gone back with like a phone book and be like, oh well. He did the mom thing where it's like, you will sit down, you will shut up, and we will eat in this diner. So help me God. Oh, is our bloomin' onion back? Thank you so much. You're such a sweetheart. Thank you. No, we're doing fine. Do it again. I will take you out to this van. You know, the mom thing.
Talking about those cross country, I saw an old lady at right over here. There's a few smaller convenience stores, and she came walking with that, very energetic in a too tight liquid, kind of like when guys start riding bikes when they're 45 years old. Don't do it,
Can
guys.
we stop spandex? No.
But it takes down the time. No, losing 100 pounds would help way better on your time. She was walking with that, and it was her hands were moving like this. The thing that just made it funny was with all of that, and her head was just red because she still had one of those face coverings on, and I was just, oh my God, you're one of those people. out exercising.
I will say, I always get accosted by the Walmart walkers. I am slower now. I try to stay out of their way, but they are always in the aisle I'm trying to go in, like speed walking side, to your left. And I'm like, ma'ams, I am just trying to get chips unaccosted.
Have you ever pointed at the door and said, "There's outside, go out, do your exercise out here. This is a store, ma'am. This is a
No,
Wendy's."
because I think some of them live in my neighborhood. I live in a neighborhood that, like, every bulletin we have, a celebration of life. So, I see a fire truck roll by. I'm like, I guess we have a new opening in the HOA. Yes, I am
That's like
dark
my
and morbid.
HOA. And Brandon, yes, stop spending all the money on Lycra and expensive bikes. Just lose 100 pounds. You'll go way faster than any bike could get you, and get some
True.
EPO. That worked for Bjarne Riis when he won the Tour de France. Zugspitze.
All right, we're back on the record. Case number 2020 CF 2603, State of Florida versus Sarah Boone. State.
Dave Castro on behalf of the state. William J. for the state.
Defense.
James Owens for Ms. Boone.
Ms. Boone is seated at council table wearing the same clothing from this morning. Madam Court Reporter, have you had the opportunity to review the transcript as to the proffer of Dr. Werner's testimony?
Yes.
Okay, you may proceed.
No, this is because of her, she said something that she didn't say before, and now he claims that the state bushwhacked him, but the state didn't know it either.
By Mr. J, question. You've been present for all of this hearing, yes, doctor? Answer, yes. Question, am I misrepresenting any of our conversations? Answer, no. Question, all right, so if I ask you if battered spouse syndrome or PTSD has any relationship to the facts of this case and the defendant relayed them to you, what would be your answer? Question, that it's not related to the incident as she reported it. Question, okay. And if I ask you, therefore, if there are any prior instances of violence, would that change your opinion? What would your answer be? Answer, no. Question, if you reviewed any other materials, would that change your opinion based on what she told you about what happened that evening? Answer, no. Question, all right, that's it.
I don't think that's the very beginning, before I objected.
What was asked was to read back the proffer.
I thought I was asking to go back to the very beginning when the question was asked and then her response and my objection to it.
What was specifically asked was to the proffer, because the question before the court was whether the proffered opinions are at odds with what was testified to during the course of the deposition.
We will thank you when Kamala becomes the president. Thank you, expert.
There's
You didn't vote for me?
a question that was asked, and the answer that was given affirmatively provided an opinion as to PTSD. I think Mr. J admits that. Mr. J has advised the court that's not what he was hoping the answer would be, that the answer was supposed to be something different, as identified in the proffer, which is why I had Madam Court Reporter read back the proffer. So the question Mr. Owens posed to you is whether the proffered opinions that Madam Court Reporter just read back to us are different than what was provided in the deposition.
Yes.
How so?
She tended to explain in the proffer some legal reason why it did not apply in her opinion. That was not discussed in any way in the deposition.
Okay. My question is specific as to opinions. Her opinions were as to battered spouse syndrome or post-traumatic stress disorder and their relationship to the case based on the defendant's responses. The answer is not related to the incident as the defendant reported. Those are the opinions, as I understand them based on the proffer, as it relates to battered spouse syndrome and post-traumatic stress disorder.
I think I'd refer to page 46. Line 13 was the question, but you don't believe that she suffers from post-traumatic stress disorder in your opinion. Line 15, the answer is no. I would have to look back through my notes to see if she fully met that criteria. Question 17.
Mayor, can we
explain
scrap
why you
this
don't
expert
think
and just bring
she
Ken and
suffers
Bro
from
back?
post-traumatic stress disorder? Line 19, the answer no. I didn't say one way or the other. I would have to look back through my notes for that. Question number 21. Is that something that you may, in the future, give an opinion about after some time reflecting and reviewing your notes? 24. I may. 25. Okay, and that's something you will let the lawyers know about if that changes. That's on page 47. On to yes. That's fundamentally, substantially, materially different from what she's testified as it relates to post-traumatic stress as it applies in this case.
In the proffer?
Excuse me?
In the proffer? She's not rendering an, unless I misunderstood the proffer, she's not rendering an opinion on PTSD and whether or not Ms. Boone suffers from it.
Well, she led me to believe that she was trying to decide whether or not Sarah Boone suffered from post-traumatic.
But if she's not rendering opinion on it now,
my
it doesn't
God.
matter if she was trying to decide it or not.
We spent 100 gajillion seconds on this, and I'm still no clearer because this isn't an argument.
Post-traumatic stress. Now, in the proffer, they're claiming that post-traumatic stress does not apply. I don't know what the initial question was. We haven't had that read back when it was first going on, when a question was asked, and I believe she rendered an opinion. And I, again, like that to be reread back. What the initial question was, what the response was, because it did. I know I objected. I can't even remember it now. But I know I objected because I knew it was inconsistent.
You asked to approach, and then you explained that the question was, it was not something that was framed in the deposition. Multiple times I asked you for a legal objection. And it wasn't until right before or right after we sent the jury out that you provided some legal objection. You know, Madam, if you want Madam Court Reporter to go back and read the question that led us to where we are right now and the answer, I'm totally on board with that. I have a memory of what it was, but nothing like.
Before she does that, can I get the first question of the proffer? If BSS or PTSD has any, can you reread that? So
Let's just reread the entire proffer, just so that it's clear, soup to nuts, alpha to the omega, what the
Nuts?
proffer was. Madam Court Reporter, if you could be so kind.
It's an Americanism.
Yes, ma'am.
Thank you, Joyful.
By Mr. J, question. You've been present for all of this hearing, yes, doctor? Answer, yes. Question. Am I misrepresenting any of our conversations? Answer, no. Question. All right. So if I ask you if battered spouse syndrome or PTSD has any relationship to the facts of this case as the defendant relayed them to you, what would be your answer? Answer. That it's not related to the incident as she reported it. Question. Okay. And if I ask you, therefore, if there are any prior instances of violence, would that change your opinion? What would your answer be? Answer, no. And question, and if you reviewed any of the materials, would that change your opinion based on what she told you about what happened that evening? Answer, no. Question, all right, that's it.
Thank you,
And
Joyful.
if she could go back to the initial.
We're happy to keep you company. Thank you for keeping us company.
What's the number 2 rule? You don't piss off the jury. The jury knows that one of them can only stay until 5. They don't want to stay here another week. They were probably told this was going to be 2 weeks, but you know that jury doesn't want to stay or come back in Monday.
Yeah, and again, I don't know the legal basis. I don't know why I objected. Jose Bias 2.0. He's a great lawyer. He's going to make me my $1 million. Well, she got the best attorney her money could buy.
Yes.
Then he only goes nuts to butts. Shalom, I'm with you. He's not stalling. He's just trying every which way he can because he knows this expert is better than his expert.
Yeah.
And he wanted the jury thrown off so they didn't get to listen to her.
And if Owens was really this pissed off about the deposition, then he had no problem this entire week. He didn't say, you know, hey, I need another deposition of their
Pay no attention to
expert.
me. Go ahead. My understanding is it was the question and the answer right before Mr. Owens asked to approach.
Question, what was your opinion? Answer, my opinion was that she did not give me enough information to diagnose her with post-traumatic stress disorder at the time that I evaluated her in the jail.
Can you read that for me one more time, please?
Yes.
Both the question and the answer.
Question, what was your opinion? Answer, my opinion was that she did not give me enough information to diagnose her with post-traumatic stress disorder.
So she has no information. She has no opinion if she has post-traumatic stress disorder.
At the time that I evaluated her at the
Yeah,
jail.
she didn't have 9 visits. She had 1 visit.
What does Owens want legally?
Question, and in this particular case, did you require any additional information to reach your conclusion about the relationship between battered spouse syndrome and the events of this evening? Answer, I based my opinion on the information that I had. Certainly, if there was more information, my opinion would be subject to change. Question, what was your opinion?
Mr. Owens?
Number one, that question and answer, she gave a differing opinion than what she gave in her deposition, which, subject to the agreement we had, I should have noticed. Number two, with the proffer, it seems that she's going to find that post-traumatic stress disorder did not apply to the facts as related by Sarah Boone. And that is an opinion that I needed to know about. And I asked throughout this deposition and at the very end some general, if you have any new opinions or anything new that differs from what you said here today, please notify the lawyers or words to that effect. So it's an evidentiary issue. I've got a right to be prepared for the trial through discovery to know what the witnesses are going to opine. And this is a discovery violation based on 2 things. One, her initial answer to the question that I objected to, and then 2, the proffer is a new opinion. It's a discovery violation. I ask that the witness be stricken.
Any response?
Judge, I think it's clear from my original question that the intent that I stated was the intent of my question, to get the answer that I intended to get, was what the question was intended to elicit from the witness. As far as the discovery violations and continued attacks, I'm just not I'm not convinced he understands what the answer means or what it's going to be. The answer isn't going to be Ms. Boone didn't have PTSD, hence, therefore, battered spouse syndrome doesn't apply in this case. Mm-hmm. What I believe she's going to say, and what I believe I've been saying,
he's now going to say she couldn't diagnose her either way if she had PTSD, but it didn't mean anything for her opinion. That's clearly what she said, but he mistook it as I diagnosed her with not having PTSD, which is nowhere near what he said.
No, and it's also, she's being credible as a professional. You cannot diagnose someone, I would think, I'm not a, mentalologist, but with PTSD on, 1 8-hour kind of, talk. And she's basically here to render an opinion as to whether Sarah Boone's actions were motivated by, PTSD, battered spouse syndrome. Because Sarah didn't proffer enough when they were talking for those 8 hours, she rendered an opinion that isn't going to include PTSD. So the jury, as the ultimate finder of facts, they're going to have to decide which expert they believe. Do they believe the expert that got to meet her for 9 times and, made all the microaggressions, macroaggressions, and whateverness? Or are they going to agree with this woman who maybe had a more clinical conversation with her? Judge Browse, make sense of this. Jump into the breach, please, because I need it.
She didn't diagnose her as not having it. Her opinion is that even if she does have it, it is irrelevant to what happened in this case. Exactly. And Owens doesn't understand that because in his mind, she's saying she doesn't have PTSD. And in no way, shape, or form is that what she's saying. She's not rendering an opinion that she doesn't have PTSD, and that makes it a Brady violation. But sadly, he's like all these people who think that you can accidentally, unintentionally self-defense.
Thing she's going to say, based on our conversations, was irrespective of whether anybody believes Ms. Boone had BSS or PTSD, it is irrelevant because of what Ms. Boone told her happened at the time of the event. That is not a discovery violation. She was specific in saying, if you have any questions you want to ask me, I'll give you an opinion. That is exactly what she said on page 67 of the deposition in response to a question that starts at line 7. Question, just double dog sure, you admit that you have no other opinions other than the ones you've expressed here today. Answer, that I've been asked about. If I'm asked about something else, that I'll offer it. They didn't ask about the interplay of the facts with the relevance of the syndrome. That's them, not the state.
Any other argument?
The totality, if you read that deposition and all that we talked
I
about-
specifically asked you, Mr. Owens, to point out for me
What?
excuse me, I specifically asked for you to point out specific portions of the deposition that are at odds with either A, the opinion that was previously given, or B, what was proffered to. You have provided me pages 45, 46 of the deposition relating to specific opinions on whether or not Ms. Boone suffers from post-traumatic stress disorder. Are there any other portions of the depo that you would like to point out for me? I am not going to read an 87-page deposition and continue to waste our jurors' time as we try to find a solution for the situation that is now before us. If there are specific portions of this deposition that are at odds with the opinions that have been proffered and or provided so far, I would ask you to direct my attention to them.
Well, the ones that I expressed.
Other than what you've already identified.
The ones that I expressed, and that just the understanding that we had, that she, in the pages that I have talked about previously here today, the pages that I referred to about our agreement, that she was going to let me know if there were any opinions that she
You've
had.
said this
in addition
before.
to the opinions that she.
Yeah, and she said, if you ask me, I will give you your opinion. She's not, yeah, I'm going to call you up Sunday and tell you how I feel.
No,
But
and
more
she's
importantly,
not. Yes.
let's all say happy birthday again. Now Sue is here. Sue, you are allowed to use 2 C words and 2 F words, not in chat, but you can yell it at the screen. Church of Mo allows it.
Blessed be.
Gave the transcript.
Okay. All right, thank you. All right. Any other argument, Mr. J? Okay, thank you very much. All right, the court has had the opportunity to listen to the proffer as read back by Madam Court Reporter, the read back of the opinion that was previously offered, the portions of the deposition which have been highlighted by the defense specifically pertain to opinions by the defendant as to whether or not the defendant suffers from post-traumatic stress disorder. That opinion is not being offered. The opinion pertains to the relationship of battered spouse syndrome and or PTSD as it relates to the facts of the case as the defendant has relayed them to you, and that they are not related. However, the deposition is identified by the defense identifies that if there were any additional opinions, that there would be notification. So the court at this point in time, as there has been an alleged discovery violation in accordance with binding precedent by the 6th District Court of Appeal, which is binding on this trial court in Young v. State, 369, Southern 3rd, 1243, at pinpoint 1248, the court is now going to conduct a discovery violation or discovery Richardson hearing. State any other arguments with regard to the elements of a Richardson hearing?
No, sir.
Okay, thank you. Any other arguments with regard to the elements of a Richardson hearing, Mr. Owens?
No, other than I understood, she did give an opinion about post-traumatic stress in that initial series of questions.
Okay. All right, the court, again, reviewing the proffer and the opinion, finds that the state's violation was inadvertent based on the proffer by the state, which was agreed to by Dr. Werner as to the conversation they had last night, as to the opinions and whether or not that they had changed. However, I do find that that violation is substantial with regard to the opinions based on the testimony in Dr. Werner's deposition that any other additional opinions would be notified to the defense. As it relates to the third category, the effect on the defendant to properly prepare for trial. Although the questions in the deposition as highlighted by the defense so far are do not address the opinions being currently offered, I do find that it had some impact on the ability for the defendant to properly prepare for trial. As it relates to the opinion that was previously provided as read back, specifically my opinion was that she did not give enough information to diagnose her with PTSD at the time of the evaluation at the jail. What is your position, if any, with regard to that opinion now that the jury has heard it? Mr. Owens. Because my question is, do you want it struck?
On that issue, we'll address it on cross-examination.
So you do not want it to be struck, and you do not want a curative instruction.
Well, I'm going to question her about post-traumatic stress, so it's going to come out through my cross from the deposition about what she said, and then it's inconsistent with what she said here today, so I'm going to want to rely on that question or that answer.
Okay, all right. Ms. Boone, have you been paying attention to the questions and answers and the readbacks of both the proffered testimony and the opinion testimony?
Yes.
And are you on board with the strategy not to seek to strike that opinion?
Yes.
Thank you. With regard to the proffered testimony, I'm going to permit now in open court, and I will oversee the deposition for you, Mr. Owens, to inquire as to those opinions.
I'm sorry.
With regard to the proffered opinions, the court will oversee a deposition now.
So, was that a win for Owens? No, because he then turtles back right in his yell and said, "But I really want to talk to her about it because I want to slam her on cross and say, my guy said the other thing." So he didn't even want it struck.
So, and he does have a point. It was changed from the deposition. The problem is that he didn't make a coherent argument. He didn't have, case law. Hey, she changed this. There was supposed to be this, according to, blah, 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 subsection B. They're supposed to notify us. And then it's also very strange that he got what he wanted. It can be struck, but then he's like, "No, I'm gonna bring it up." Then we wasted an hour and a half for you to again not get it stricken from the record.
Well, remember, if it goes to appeal, then it will stay in the papers. So that's why you strike things. Win is still a win technically, but it doesn't change anything, and it doesn't matter. And his cross-examination is going to be horrible.
And you may proceed.
Right now?
Yes. With regard to the
Now we're
proffered
going to
opinions.
do a deposition.
Yeah. Now
And I believe that will provide a cure for the discovery violation under the Richardson violation based on your
Who the hell gave him a Red Bull?
prior opinion. And since you're going to utilize that on cross, I find that the prejudice is limited. But with regard to the new opinions, I will give you the opportunity to depose her now, curing the prejudice at that point in time. You may proceed.
Dr. Warren.
Yes, sir.
Good morning.
Good morning.
At some point, the state attorney notified you that you were to come today.
Correct.
Did you and the state attorney have a discussion about your testimony?
Yes.
When was that discussion?
Briefly last night.
So y'all talked on the phone last night?
Yes.
Have y'all had any discussions since the phone conversation last night?
Briefly this morning.
And how long was the phone conversation?
Less than 5 minutes.
How long was the face-to-face conversation?
Less than 5 minutes.
Did y'all discuss that your testimony would be that you did not have enough information that you gathered from Sarah Boone to form an opinion as to whether or not she suffered from post-traumatic stress disorder?
Correct, that my opinion hadn't changed.
I'm sorry?
Yes, that my opinion hadn't changed, that I didn't have enough information.
Okay.
That's what
And
she said.
did the state attorney speak to you about that it didn't matter whether you had an opinion if you didn't feel like the facts that Sarah Boone had given you as it relates to the facts and issue in this case, that you didn't, if you didn't feel like post-traumatic stress even applied, then you could answer that way?
Correct, that was my opinion, correct.
But did he present that to you initially for you to form an opinion about it?
No, my opinion was that it didn't apply because of the way that she described the incident to me.
Was that your opinion back when I took your deposition?
Yes,
When did you form that opinion?
when she described the incident to me.
Why didn't you let us know that was your opinion at the time that I took your deposition?
You didn't ask me about that, sir.
Do you remember me asking you any other opinions that you may have as it relates to this case?
You didn't ask me specifically about that.
I understand that, but you're saying you formed that opinion prior to the deposition, correct?
Yes, the state attorney and I discussed that on the way out of the jail, as a matter of fact.
After the deposition?
No, sir, after the evaluation.
Okay.
On the way out of the jail.
All right, and I asked you, were there any other opinions that you may express at trial after you had discussed that with the state attorney prior to the deposition? Is that correct?
Yes,
And so you were aware that I didn't want to be ambushed at trial. I wanted to know any and all opinions that you may be expressing in the Sarah Boone case.
I didn't know what specific information you wanted, sir. That's why you had a deposition. I answered your questions. I don't know what all information you want me to provide to you.
So because I didn't ask you specifics, you felt like you didn't have to respond specifically.
Mo, do you like colors?
Yes.
No, sir, I answered all of your questions. And as I said,
Mo lied because she didn't tell me what specific colors she liked. I will now rule this a mistrial. You can't just say you like colors. What colors do you like? Why didn't you follow up and tell me afterwards when I didn't ask you?
So this would be like
yogurt.
my kids.
I had yogurt. No one asked me, but I just told you what I had for breakfast.
So when youngest and middlemost Farrell decided to drop a big giant rock on a can of spray paint.
I'm happy to answer any.
Sorry. No, he can't move to strike her as a witness. He tried to do that. He could move to strike her that PTSD had nothing to do with it. And now he's going to go yell at her in front of the jury just like this, and then all the winning is going to go away again. This guy is incompetent, a loser, and he's lucky that Judge Browse is ruling that way because there was no violation. He totally misunderstood the statement that was made. Sorry, Mo.
So this would be like when my kids dropped a big rock on a can of blue spray paint. And the first thing I heard was, nothing happened. I don't know why I look like a Smurf exploded on me and smell like spray paint. So then I had to ask, okay, I can smell spray paint. So this man had an opportunity to go in to ask why she smelled like spray paint. And he didn't. And now it's her fault that she didn't, give him a bunch of information he didn't ask for, because he's the type of lawyer that's going to say, that's enough. That's enough. It's a yes or no question.
Yeah. He is one of those who, when he gets caught up in his own ineptitude, will blame everyone else.
Questions that I'm asked. I don't know what questions you want me to answer.
But you know that this was a central issue in the case. Did you not? Your opinion
Yes.
is relating to a central issue in this case.
Correct.
You're aware Sarah Boone's on trial for murder.
That's
And you had this opinion when I was taking your deposition, and I was asking you specifics about any opinions that you may be expressing in the trial of Sarah Boone, and you did not disclose it.
Well, I told you that I would answer any questions that were asked of me. I have a number of opinions. I know that I don't feel that she's suffering from major depressive disorder. I didn't offer that opinion either. I have a number of opinions.
That's all the questions I have.
Mr. J, anything else?
I'm just making sure you want to inquire,
This is your opportunity, Mr. Owens.
because that was more just about.
Inquire about what?
This is your opportunity to inquire. You are conducting a deposition. This is your opportunity and your only opportunity to cure any prejudice that we've identified with regard to those proffered opinions as it relates to the relationship of battered spouse syndrome and or post-traumatic stress disorder as proffered.
The problem is now, Judge, is I've got my expert, and we weren't aware. You know how in these type cases, the experts are allowed to listen to the testimony of the other experts and read the depositions of the other experts. Dr. Warner, were you given the opportunity to read Dr. Harper's deposition?
I was.
I mean, that's standard operating procedure in these type cases. And now I'm taking a deposition on the fly, and then I haven't had a chance to speak with my expert about those opinions and whether or not that would change her opinion. It just puts me in a very difficult situation. But if I'm ordered to continue the deposition, I will.
That's your decision. It's not an order. I'm just saying that this is the opportunity to cure that Richardson issue. You asked previously to strike the expert. I am disinclined to do that. The case law says that is an extraordinary remedy, one which I am not going to permit.
Dr. Warner, you realize you're in a courtroom.
Yes, sir.
And we're waiting on the jury on the trial of Sarah Boone.
Yes.
Are there any other opinions that you intend to express in this trial that you have not disclosed to me in the deposition, or you have not disclosed here today under oath?
I'm happy to answer any questions that I'm asked.
Are you refusing to answer my question about any other opinion?
Please, I'm arguing with one on Twitter now. How can you see him as a wonder child? He's yelling at her. Are you going to say any opinion? If
Ask
he
her a
now
specific
goes up
question.
there, yeah, he goes up there now and say, "Do you think she has a pink shirt on today?" No, my opinion is it's burgundy. You didn't state you were going to offer that opinion. How can she answer? You're so.
Well, and how does she start
start
just giving
thinking.
out facts? I gave her the multiphasic Minnesota test. I gave her the personality test. She doesn't score high enough. I did this clinical. What does he want? Again, this
Yeah.
is such vague booking right here. What do you want to know? Why are you, what is the part that you would like to go to your expert with, a counter opinion?
Yeah.
Do you?
She didn't find she had PTSD. Will you change your testimony that she did have PTSD? It doesn't put you in a bad position because you're going for PTSD defense. It doesn't change anything.
Opinions that you intend to express here today as it relates to Sarah Boone, who was on trial for murder in the second degree?
But I'm going to object. The catch-all vague question that Mr. Owens wants to ask this expert witness about any and all opinions she may or may not have. 99 out of 100 attorneys will come in here and say that's not how you do depositions with expert witnesses. You have to ask specific questions. Anytime you ask a question like that of an expert, the expert's always going to say, please ask me a specific question. And that's what she did then. That's what she's doing now. It's unfair and vague to ask somebody, tell me everything.
That's why I feel this Richardson hearing is bullcrap. The judge shouldn't have allowed it because he didn't have a legal ground to stand on to begin with because she didn't give the opinion that he claimed she did.
Judge,
Yes, sir.
we're in the middle of a trial. She's fixing to testify. She's had conversations with the state attorney. She knows what she's going to be asked in forms of opinions that she's going to express. That's why she's here, to help the jury understand the science that relates to the law and express opinions. I mean, for me to ask, we're playing hide the ball here?
No.
In the middle of a trial.
I disagree that there's any hiding of the ball. There's been a proffer that's been read multiple times as to the scope of the opinions regarding to battered spouse syndrome and post-traumatic stress disorder and its relationship to the facts of the case as the defendant represented them. And the answer is they are not relatable to the incident as relayed by the defendant. That is the opinion that have been proffered.
Can I continue with my deposition? Yes. Dr. Werner, do you recall expressing that you wanted more time to reflect as to whether or not Sarah Boone suffered from post-traumatic stress disorder?
Yes, that I was going to review my notes to see if I had enough information in there to support or negate that.
What additional information would you need for you to express an opinion that she suffered from post-traumatic stress disorder?
So she did not give me information regarding the presence of intrusive symptoms. She didn't give me information regarding persistent avoidance. She didn't give me information regarding alterations in arousal or reactivity.
Anything else?
No.
Would you agree you failed to ask her those questions?
I asked her if there was any other important information that she felt like she needed to share with me at the end of my evaluation, and she said no.
So a catch-all question.
Correct.
Were there any other
Goose
personality
standard?
disorders? Isn't that what you do as a psychiatrist? You diagnose an opinion, express opinions about whether people suffer from personality disorders?
Correct.
Are there any other personality disorders that you have formed opinions about Sarah Boone that you intend to express?
No.
So narcissism, you did not find.
I found narcissistic traits.
In terms of your opinion that she suffers from narcissistic personality disorder.
No,
No.
sir, I said narcissistic traits.
Again, this man doesn't understand the deposition he sat in on. She constantly said narcissistic traits. Your own expert said she had 3 of the at least 5 needed out of the 8 traits to be deemed a narcissist. When she was cross-examined, there was 4 traits. Jesus.
So you don't have an opinion that she suffers from narcissistic personality disorder.
Correct.
No.
She displays narcissistic traits.
You express an opinion that she suffers from alcohol use syndrome,
Alcohol use disorder.
alcohol use disorder.
Correct.
Is that still your opinion?
Yes, it is.
Anxiety disorder. Is it your opinion she suffers from the anxiety disorder?
No.
Do you recall in your deposition indicating that you felt like she suffered from either anxiety disorder or adjustment disorder?
That's correct.
And you changed that opinion now?
I'm leaning towards a adjustment disorder secondary to her legal situation.
So you haven't formed an opinion as to whether or not she suffers from general anxiety disorder or adjustment disorder?
Correct.
You agree that she suffered from trauma as it relates to the domestic violence history that she expressed to you from the intimate partner violence with George Torres?
Yes, as reported by her. Yes.
Do you have anything to dispute that?
No.
As reported by her. I think she's an unreliable narrator.
Yeah.
In your opinion, does she suffer from any form of psychosis?
No.
Is it your opinion that Sarah Boone suffers from acute stress disorder?
No.
Is it your opinion that Sarah Boone suffers from intimate partner violence?
Yes, I think that there is enough history of the volatile relationship between the two of them.
Because of that, do you believe that Sarah Boone suffers from battered spouse syndrome?
She may meet the criteria for that.
May. So it's possible? Is that your opinion?
Yes.
Definitively, you can't say?
There's a history of her having that. Yes.
So you agree she suffers from battered spouse syndrome?
Yeah.
I believe we've covered anxiety disorder, narcissism, battered spouse syndrome, and alcohol use disorder. Are there any other opinions that you intend to express as it relates to that or any other psychological condition of Sarah Boone?
No.
That's all the questions I have.
Any other arguments at this time?
No, Judge, just the one I've already made.
Okay, all right. The court has conducted its Richardson hearing and made its findings. The court, as previously identified, will not strike the expert as that remedy is quite draconian, and I will not do so based on the questions that were asked as highlighted by the defense and the opinions that were offered. The specific areas for which opinions are being offered were not inquired into, but the deposition did leave it open that I'll ask questions about any other opinions that I'm asked about or anything else that I'm asked during the course of the trial, specifically page 59, 22 through 26 on 1, page 60.
Let's go there the entire time. It's only you who comes in to do the racism jokes.
lines 11 through 25. So in the abundance of caution, the court has permitted that in-court deposition. Anything else, sir?
No, sir.
State, anything else?
No, sir.
All right, let's go ahead and bring back in our panel and we can,
Before we bring the jury back in, may I approach Mr. Cacciatore on a completely unrelated matter?
does it need to be on the record or?
Yes,
Okay, go ahead.
We would concede that Detective Copsell and Detective Lowen are not testifying against us. They've been here in court this morning.
They're still under defense subpoena.
I
We have
asked,
not,
excuse me, I asked Mr. Henderson if you guys were calling Detective Capsule again, and he said no.
and we're not, in our defense, our direct defense. Is there a possibility that based upon the information the state is going to present today or this afternoon, that we may want to receive or seek sir rebuttal, and possibly through these witnesses? They're under subpoena, and I'm sorry, Mr. Henderson's not here. I've just noticed her presence. Out of an abundance of caution, I think that we need to clarify for the record that they're here listening to.
What's your basis? Well, we're off the record. There's no jury here. That's fine. Y'all stay where you are. What's the basis for your sir rebuttal?
We don't know because I don't know what the state's going to place in rebuttal. But
It doesn't answer my question. What's the legal basis of a sir rebuttal?
We don't have legal basis. We just make it up as we go.
The defendant pursued.
Okay. Anything else, Mr. Cacciatore?
No, Your Honor.
Okay. The rule of sequestration is still in full force and effect. Detectives Lowen and Capsule, good morning. I'm going to ask you to be excused from our proceedings and not view them and not have any communication amongst yourselves about testimony that has been previously given or any questions that have been asked or answered, and just keep your separate ways as it relates to this case and any questions or testimony that you intend to give, may give, or have give, and to comply with any instructions.
Ha, Zach, Mo doesn't read your chats either.
Oh, thank you for the $2, Zach. And Baker never reads my chat. I'm coming over here. Well, you know,
That were provided.
you can't just go to anyone else's house or, you know, every other parent's house when you get told no somewhere. Thank you, Zach.
To you by the state regarding the rule of sequestration. Thank you very much. Anything else, Mr. Owens, we need to address?
No.
Anything else, state?
No.
All right, let's bring back in our jury. You can continue your inquiry, sir.
That's because they were released. So we didn't
They were
know.
released from the state, but not the defense. So if
So they were
anything is
released
brought
from
up in the,
they were released from the defense after the defense was after the defense
Oh.
was involved. And now they want it back.
State to recognize our jury. Yes, Your Honor, that's to recognize our jury. I think I'll be seated. Members of the jury, thank you again for your patience. We had some issues I had to address with counsel outside of your presence, and we're going to continue the state's rebuttal case this morning. Again, if you could please just raise your hands to confirm that you complied with the court's instructions during the break. Record reflect all hands have been raised. Mr. J, you may continue your inquiry, sir.
State would move to strike the last response as non-responsive.
Approach.
just when we think we're going to get going.
Yeah.
Can it be Friday yet? I think we're going to need a drink after this. Good night, nurse. Well, Zach, I hope you have Zydeco music, and it's going to hurt you more than it hurts me.
Irrespective of whether anybody has an opinion about whether Ms. Boone was suffering from PTSD or BSS, irrespective of that, based on your evaluation of Ms. Boone and what she relayed to you about the facts of the case, does PTSD or BSS have any relation?
Objection, that's an asset answer.
Overruled.
No.
And what particular part of her statements about the incident is that?
The whole part where she's describing the part about playing hide and seek and that they were having a good time, they were laughing, when he got in the suitcase, when she found him, they were enjoying themselves, she zipped him up, they were still laughing, you know, having a good time. All of that isn't consistent with her having a feeling of she had imminent risk or imminent, you know, there was an imminent risk of harm that she needed to protect herself.
Can we proceed?
Yes.
Oh. She is allowed as an expert to testify what she based her opinion on. These are all statements Sarah Boone gave to her, so she's allowed to base her opinion about it. Yeah, I don't know really
Yes,
know if
old
the
line
defense is
red.
getting a sore rebuttal.
Yeah, we're getting penny problem glasses from HR back. I will say she conducted herself very reasonably when Owens was having his Twitter patient attack on there. Like, how are you going to say you can't handle the truth? And M169, this is the state's rebuttal. So this is their expert witness who only got one session with Sarah. So in that limited time, just talked about the event. And with her knowledge of that, her other past clinical diagnoses and things like that, said that while she might suffer from PTSD and might have some of the underlying characteristics of battered spouse syndrome, it was not a factor in this particular event. There was not an overt act. There was not an attack on Sarah Boone at this time. So that's what she's basing her things on. Carla, I know what you mean. I want to get more unicornios for my display case and trying to be all minimalistic and stuff.
Members of the jury, I have something I've got to discuss with counsel outside of y'all's presence. Same instruction, please don't conduct any independent investigation or research on the person, place, thing, or charge involved, and don't have any conversations among yourselves or anyone else with regard to that, and we'll bring you back in as promptly as possible. Thank you.
What in the grounds is this?
He's allowed to base an opinion on the testimony she gave to her. That's what she said.
Welcome to see it. Thank you. Madam Court, when you're ready.
Carla brings up a good point, because it's one thing to win an objection, but constantly getting shifted out, and you're just standing out in the hallway thinking, I need a cigarette, but I can't go outside smoking because I might be in there in 1 minute, I might be out 30 minutes like I was before. You can sour the jury against the defense team with all of this nagging. Well, you didn't miss much because we were just on another break.
And the jury will take this out on his client. That's the problem. Juries, I guarantee you, the one that's had to arrange for a child to be picked up late at night because of the 6 p.m. Trial days, she's going to be looking at her watch like, he or she, what am I doing here? They couldn't have done this morning. They get in early. There's a lunch break. What are we ticked off about now?
Yeah. We have had what? Less than an hour of court time.
Just go from there. Read it from the question, answer, question, objection. Let's just have we can buttress it. Go ahead.
By Mr. J, question, all right. Irrespective of whether anybody has any opinion about whether this building is suffering from PTSD or DSS, irrespective of that, based on your evaluation of this building, what she relayed to you about the facts of this case, does PTSD or BSS have any relation? Mr. Owens' objection asked his answer. The court overruled the witness, no. Question, and what particular part of her statements about the incident is that? Answer, the whole part where she's describing the part about playing hide and seek, they were having a good time, they were laughing. When he got into the suitcase, when she found him, they were enjoying themselves. She zipped him, they were still laughing, having a good time. All of that isn't consistent with her having a feeling that she had imminent risk of harm.
Any other argument, Mr. Owens?
That invades the province of the jury. That's a decision whether or not she had imminent risk of harm or perceived an imminent threat is a question for the jury. This expert can express opinions on science, on medicine, but not on the ultimate issue of fact, and explain to the jury that this defense doesn't qualify, that you should rely on me as an expert, and I'm going to make the decision for you, ladies and gentlemen of the jury, by telling you
No,
that
she's
under the
giving
facts
you her
expressed to me by Sarah
opinion.
Boone,
Yeah,
she was
that's
not
her
perceiving
opinion
an imminent
based on
threat
her
at the time.
testimony.
Response.
It's not an objectionable opinion. It's not an opinion on the ultimate issue. It's an opinion upon the applicability of a particular set of evidence that testimony that the defense has offered, called battered spouse syndrome, to kind of help explain a portion of the justifiable use of deadly force or non-deadly force instructions. She's not up there saying Ms. Boone was unjustified in doing what she did. She's not saying that justifiable use of force doesn't apply. What she is saying is, in her opinion, based on the facts that she relies on, given by the defendant herself just a couple of weeks ago, that this particular set of testimony and evidence that has been offered through their expert, Dr. Harper, doesn't apply. This is no different than one expert coming in and saying, well, yeah, you can know that the defendant was sane at the time, despite his mental illness, because he ran from the police, he hid, he concealed evidence, so on and so forth. And therefore, because of those facts, insanity doesn't apply. And a defense expert may come in and say, well, insanity does apply because my client, after stabbing her mother to death, called 911, was speaking unintelligibly and singing, and greeted the officers at the door with a pair of knives, and wouldn't drop the knives, and was incoherent for 12 hours after the offense. Therefore, based on those facts, the expert says, well, insanity does apply. It's not becoming a lawyer, it's not becoming the juror, it's explaining a particular type of expert testimony, and it just happens to disagree with Dr. Harper's. And Dr. Harper came in and said that BSS does apply, and that she was in constant fear, and the reason she's in constant fear is because of all the past episodes and whatnot. It's permissible testimony.
Any other argument, Mr. Owens?
That's totally wrong. The prosecutor claims Dr. Harper came in and said BSS does apply. That's true. But he just got through saying and trying to get the witness to say BSS, it's not to be regarded. Post-traumatic stress is not to be regarded. It doesn't even come into play. Post-traumatic stress disorder, battered spouse syndrome does not even come into play because at the time she was facing, according to this witness, no imminent risk of harm. Therefore, you can discount everything you hear, ladies and gentlemen of the jury, about battered spouse syndrome.
She didn't say that. Again, you are. I was under the impression. So say like Amber Heard and what's his Gollum or Smeagol. Dr. Muffins was like this, and this means something, and Dr. Spiegel was like, I watched a movie and I have my precious ring. What are we doing here, Baker? Make it stop.
I just want to reiterate. People believes he is a great lawyer. He is the new Jose Baez. He just, for the 10th time today alone, totally misstated what the expert said. He should be reprimanded, not to misstate what she said. She just said, based on what she said, there was no imminent threat of danger. She never said, well, then you can disregard everything else. He's implying that there's an unverbal communication going on with the jury that no one else but he can hear, where she claimed that because I have this opinion, you have to disregard everything else. This is other BS. He knows from his proffer, he can get her to say, yeah, there's some type of BSS going on. Oh.
The irritating thing is I can kind of see where he's going with this, but his argument is so bad. And it's not coherent to me. And I'm not even a legal person. So I'm over here typing to Jedi Jess like, is he late in French or am I just not smart? Because I will totally take that I'm not smart, but he is not reacting like any other lawyer. And I've watched trials for years.
Yeah, he thought this rebuttal witness was here to reinforce his position. Yeah.
Have anything to do with whether or not it's an improper legal opinion under 90.703.
It is. It's the ultimate issue of fact in this case because self-defense has been alleged by the defense. And the issue for this jury is whether or not Sarah Boone had the right to defend herself with force, deadly force or non-deadly force, based on her beliefs and impressions at the time, whether they were reasonable under the jury instructions, under the special jury instructions that are going to be applied for battered spouse syndrome, under the jury instructions, under justifiable use of deadly force, whether her perceptions about the threat was imminent and whether it was appropriate or reasonable to act the way she did. This expert is trying to say that she was not facing imminent risk of harm.
She wasn't.
Thank you both for your arguments. Court is going to overrule your objection, find that it is not an ultimate issue of fact as addressed by 90.703. The court specifically relies on Dinkins versus State 976, Southern 2nd 660 at pinpoint 661. In that case, a psychologist testifies in the instant case in Dinkins, the psychologist's opinions were not legal conclusions. The psychologist did not opine on the defendant's guilt or innocence. Rather, the psychologist opined only as to whether the victim was, quote, mentally defective, end quote, and capable of consent to intercourse. Although the opinions did go to ultimate issues in the case, Florida law, expressly provides that an expert witness may render such opinion, see section 90.703 Florida statutes, which provides that testimony in the form of an opinion or inference otherwise admissible is not objectionable because it includes an ultimate issue to be decided by the trier of fact. Thus, the jury had the power to accept or reject the opinions and was not bound by such. For those reasons, your objection is overruled.
Madam Court Reporter, I'm just going to ask you to read the question and answer, and I have no further questions of the witness.
Okay, thank you.
I'm sorry?
He is going to have Madam Court Reporter read back the question and the answer, and then he is going to have no other questions for this witness.
I object.
Basis.
It was asked and answered.
Overruled. There is a pending objection. Allow the state to re-ask it so it's clear based on that objection.
Judge, it's 11:30. I'm going to need at least an hour for my cross-examination.
We're going to begin your cross-examination after we're done with the state advises the jury in open court that there are no more questions. Let's go ahead and bring back in our panel.
What in the name of Tremonelli is going on? And why is Jersey Shore back in that uniform or outfit that makes him look hungover?
Probably because he is hungover.
True, that green is not his color.
State, recognize our jury. Defense, recognize our jury. You may be seated. Thank you. The jury, again, if you could raise those hands. Juror number 2, back right. He gets it. Thank you all very much. Record reflect all hands have been raised. State, you may proceed.
Read back the question and answer.
Madam Court Reporter.
Question by Mr. J. All right. irrespective of whether anybody has any opinion about whether Ms. Boone was suffering from PTSD or ESS, irrespective of that based on your evaluation of Ms. Boone, what she relayed to you about the facts of this case, does PTSD and ESS have any relation? Mr. Owens' objection, asked and answered. The court overruled. The witness, no. Question, and what particular part of her statements about the incident is that? Answer, the whole part where she's describing the part of about playing hide and seek. They were having a good time, they were laughing. When he got in the suitcase, when she found him, they were enjoying themselves. She zipped him, they were still laughing, having had a good time. All of that isn't consistent with her having a feeling of she had imminent risk or imminent risk of harm.
No further questions.
Any cross-examination?
Yeah.
You may proceed, sir.
Dr. Warner, good morning. What all did you consider collaterally as it relates to your opinions you're expressing here today?
I had a number of documents that I reviewed. I'll look at a list. I had the Orange County Sheriff's Office investigation report. I had a transcript of a 2-hour interview of the defendant. I had a
That's the 2-hour interrogation with Detective Lowen and Detective Copson.
it was an interview, yes.
Excuse me?
Yeah,
Okay, go ahead.
it was labeled an interview. Then I had a transcript of a second interview the next day of Ms. Boone. I had medical records from Aspire Health and Advent Health. And then I had some cell phone records. And I also received the deposition of your expert.
The deposition of Dr. Julie Harper?
Yes.
Okay. And did you listen to Dr. Julie Harper's testimony in this trial of Sarah Boone?
No.
Do you agree you have a right to do that?
Yes.
And did you listen to Sarah Boone's testimony in the trial of this case?
No.
You agree you have a right to do that?
Yes.
And you elected not to listen to her testimony before expressing opinions here today?
Overruled.
I did not have time to do that.
You did not have time to do that?
Correct.
She's on trial for murder.
Yes.
Sustained.
You said you considered some text messages from Sarah Boone's phone.
I reviewed them, correct.
Would it be fair to say that of those text messages, they're not necessarily overly relevant?
Objection, you revoke.
Yes.
Oh God, that's a bless your heart. I'm going to stab you with my ladle from my great red sauce kind of look.
So he's now making her do a determination if text messages are relevant in a case. Isn't that for the jury to decide? He's just
Yeah,
looking at all the. Again, I love you all. Love you, Restless Mom, who tells me he's doing a great job and he's winning. And I know I'm wrong all the time, but I think he's a horrible, horrible attorney. And I don't blame him for doing his job. I've said this multiple times.
No.
Sarah have the right to have a defense. I think it could have been
Yes.
really funny if she was doing it herself, but I wish she had a good defense. Because this man don't know case law.
Regarding these text messages that you were provided, did that inform your opinion that you just expressed about the inapplicability of BSS or PTSD to the facts of this case?
No.
Okay.
Did it apply to your opinion that Sarah Boone suffers from battered spouse syndrome?
No.
Are that information, when you express opinions in court about a patient or about an individual, you rely on your personal assessment as well as the documents and evidence that you're provided and asked to review, are you not?
Correct.
And in this case, your testimony is that you reviewed all that information before you interviewed Sarah Boone for 2.5 hours on October the 2nd of 2024, 22 days ago.
Correct.
So you had the information,
Yes.
the documents, you read the documents,
Yes.
you read all the text messages,
Correct.
and you are going to express some opinions here today, are you not?
Correct.
You're going to express some opinions about narcissism, whether or not she had.
Yes.
I thought she just said she wasn't going to express any opinions about that. Is the Matrix glitching? Am I really Mo, or am I in a hot tub on a Twitch channel? Because What is going on here?
Don't blame the judge. The defense should praise their luck that they have the judge, because all the winning he's doing is an overabundance of caution by eyebrows.
Also, imagine you're a juror and you've heard nothing this woman has said. She's been kind, she's been measured, she's been professional. And Owen goes in. So this woman's on trial for murder and you didn't want to take the time. Again, in my layperson opinion, you should match energy, and it doesn't look good when you are trying to do a case on battered spouse syndrome and you are badgering a female professional for her opinions. Also, I would consider it professional malpractice if she was only with Sarah for 2 hours and diagnosed her with anything.
And Salty Dog just informed me that the candy have reached Indonesia. Thank you so much, Salty Dog. Most of all the giveaway packages have now arrived. So I think I figured out how to do it. I know some of you, there was some wrong with the addresses. That's why if they don't arrive, it's something with the address, the way it's written. I wrote it like everyone told me. I will be doing another giveaway next month, so you can have it before Christmas, because it takes roughly 2 weeks for it to get out there. It'll be probably some Christmas Lego ornaments, some candy, like the last time, an appreciation of all you wonderful subscribers to the channel, not the members of the channel, because if it's a paid to play, I will have to register it as a lottery, and I don't do lotteries. I just give away as a thank you. So I'll have to go when I'm feeling a little bit better and I don't sleep all the time. I'm not on screen. I will go buy some stuff, start promoting it, and we will do another giveaway stream where we'll find, I don't know, let me see how much I can find, 5-6 giveaway packages to send somewhere in the world to some wonderful members who is subscribing, listening to me yelling at everyone.
I did not think today was going to be this crazy, but apparently it is.
It's Have you seen the light up flower Lego? If you're talking about the Christmas candle, I have it ordered, but my hookup guy didn't give it to me. So I have that and a Christmas tree ordered, but haven't gotten it yet.
I will just say I have been shocked with how Owens is so aggressive. And yes, I understand he is upset. But in front of the jury, you do not want to look like an aggressive bully. And if I'm in the jury, I mean, I'm sure they were laughing hysterically when they read my notes. But I was like, what is this douchebag's problem? Why is he being so aggressive? You know, because I write things down just as I observe them. So I'd be like, why is he so aggressive? Psychiatrist or, expert not matching his energy. What is going on here?
Yeah. It's and of course I will send you some of my spunk.
I too have some Legos that I will be doing on the 4K giveaway when I can get everything scheduled with all the children's. So I have a free day that Mr. Mo can watch them. But I do have some giveaways too.
No, you just have to eat the licorice because as Jamie found out, Jamie got that care package from Pernilla, hasn't been on stream since. She is just in her bed, watching her soaps, eating candy. I don't know. Apparently they had that hearing before we started this morning. We don't know anything, so...
It's just from an outsider looking in, it doesn't look good. And I know that the jury is probably getting really ticked off.
Yeah. And we've heard that before when they talk to jurors after that. They feel they were too aggressive or It didn't roll. It didn't go. And I think too many objections can be a detriment to your case because the jury will feel, why are we getting sent out all the time?
Well, yeah, and unless you have someone like me who watches trials because she's weird, and I'm so glad I found my tribe because Mr. Mo is now protected from trial talk. But unless you have someone there kind of translating, like they're obviously having an issue with this expert, that kind of thing. It's like, why the hell are we standing up? Are we doing the hokey pokey, like put one leg in, put one leg out? This is turning into a day of Daryl Brooks.
Jamie has just reached out to me. She have had a spunk-related accident. She wanted to be on stream today, but she got both the salted and the fruity spunk, and Gilmore Girls is on the TV, and there was a spunk-related accident. She told me she would be in the Amazons saving hippos, but in reality, it was a spunk-related accident with Jamie.
I love y'all's candy.
Spunk. Keep your minds out the gutter.
That does remind me. Has anyone offered Owens a Snickers? Because you remember those commercials where it was like Kathy Bates and then he ate a Snickers and he was back to, Owens?
Yeah, they were great commercials. Jamie
also,
will kill
who
me.
gave him an energy drink?
I can tell you my phone is pinging all the time because Jamie is yelling at me because I'm saying this. Well, we love having you here, Money G, too. And I love that even though we don't see eye to eye, we don't sit here and say, well, you're an idiot because you can't see. No, we're just saying, I feel he's winning. I really can't see it. Well, I feel this is a thing. Well, I think, and I don't want an echo chamber. If you want an echo chamber, go vote to Lawn and Crim because all of them agrees on everything, or else they'll be hackled out of the chat.
And honest to goodness, I think Baker and I both, are pretty honest about our bias. Like, Sarah is not a person that we would want to be friends with. She is not a good human. I want her to have a fair trial and her lawyers to do something so that so Sarah gets the kind of justice that I want our country to have. I understand our justice system is flawed, but this is the best we have right now. And I want her to have, representation, zealous representation. I had hoped when she got a real team of lawyers that we were going to be spared this nonsense.
Shirts of beer and nachos, how much do you think it affects the jury when they're constantly brought in and out? Does it create questions that maybe it's not so cut and dried guilty case because of all of it? They are being sent out constantly on objections from the defense. So I think they are annoyed that defense gets them sent out, especially because we sit here and see that they have these discussions. Oh, and there was that Richards hearing, which I'm not a lawyer, but I thought it was wrong because she never testified to anything that the judge ruled on or stated anything that the judge claimed on behalf of Owens that she said. But then they come back in and they get the exact same question as they just had. So they must be thinking, why the F were we sent out for 30 minutes just to come in and go on? Then we go 2 questions, then we get sent out, then we come back in and we just read the last question. Why did we have to go out? That must mean that defense isn't playing the right way. They must just be, I see it like if it was me, I would see it like they have just constantly throwing everything because our defense is so weak. We want this expert out of here.
Yeah, and I think they're burning the credibility that they have. So this expert doesn't agree with your expert. Well, call her out. Ask her if they did the unified theory of Sarah-ness or whatever test that she used. And allow the expert to say, I only had 2 hours. It would be in poor professional taste of me to diagnose someone with 2 hours. You know, I didn't get 9 chances to go. I didn't get to build a rapport with her. I was here trying to give my legal and professional, well, not legal, but my professional, evaluation of this particular incident.
I think as long as all the school trips they are going on is caused by the defense, I don't think they will believe, oh, they are covering up for the defense. I don't see that. To me, it seems more like the defense is running hide the football.
Ma'am, is it fair to say,
Yeah, they could have objected during all of Sarah's testimony. It was leading all the way through, but they didn't because Mo have said it multiple times. I feel they're looking at the juror and saying, okay, let's. They never attacked anyone. They never yelled at anyone. They were very, very good to Sarah, where I would probably have gone hardcore on her. And now you have this guy yelling, and I don't think that's a good optic.
in your evaluation of Sarah Boone on October the 2nd of 2024,
Any questions you have, I'll try to see them, try to answer them. And again, it's just opinions. I don't know anything more than you do. But that's why you watch on a commentated channel instead of watching on Lawn and Crim, where you just have to sit and guess. And if I don't answer, someone in chat will probably enter a discussion with you. If it's Sue, don't mind all the C words and the F words. It's her birthday.
It's her birthday.
or that you felt like the text messages that you received from the
Yeah, I've seen her legs in a pair of tiny pink shorts. I would have gone hardcore.
state attorney
Objection beyond scope.
are not relevant to your evaluation of Sarah Boone.
I wasn't sure at the time who actually, I wasn't sure whose phone number it was. In all honesty, we discussed that in the deposition, and I wasn't sure, I have no proof of who actually sent the text, who actually had possession of the phone and put the text, any of the text in.
Well, I was there for the deposition, was I not? Or I appeared by Zoom, did I not?
No, so you were present in person.
Okay, I'm trying to think.
Oh, deposition.
The deposition.
By Zoom, yes.
You appear by Zoom, I appear by Zoom, the state attorney appear by Zoom.
Yes,
And we discussed that these were the phone records from Sarah Boone's phone.
yes.
Okay. And at that time, you said they're not necessarily overly relevant to your evaluation. Did you not say that?
I don't recall specifically. I'm happy to look at it.
Can I approach the witness?
I have it. You can just refer me to the page.
Just a moment.
I do.
Page 14. My question is at line 3. Your answer begins at line 5.
Correct.
And you agree that any,
Let him finish. Let him finish.
well, I'm going on, I'm going to ask another question about the text messages, Judge.
You just said line 5, approach.
Oh, for the love of all that is Smolies. Oh, you get that smile from her when your kids are pushing your buggy in the car or in the grocery store and they accidentally run into her. It's a southern thing. So that is a
Dr.
bless
did
your
that
heart
refresh your
smile.
recollection about our discussions about the text messages in your evaluation?
Yes,
And would you agree that they're not necessarily overly relevant to your evaluation of Sarah Boone?
correct.
And you agree that after reviewing all those text messages, that there was nothing that stuck out to you that caused you to pause and feel like they may have some impact on your evaluations of Sarah Boone? Can she answer the question?
Have her answer the question first.
I'm not sure what you're referring to in the deposition.
Page 14. My question is at line 21. Your answer is at line 25.
Correct. And I said no. As I said, it made me aware that they had a volatile relationship.
But my question to you specifically is there anything in the text messages that stuck out to you that caused you to pause and feel like that may have some impact on your evaluations?
Correct.
And you agree your answer is no?
As I said, it made me aware. That's not my complete answer.
Okay, well, let's
It
talk.
made my
First, you
complete
said no.
As I said,
Don't do this. Don't badger the witness and don't do this. Oh, I only want to hear the first part of your answer. Object
This is-
and get her to read it in context.
It made me aware that they had a
Ma'am,
volatile
ma'am.
It's not my complete answer.
I know, Dr. Warner, but didn't you say no to me? That was your first sentence, was no.
It's not my complete
I
answer.
understand. I'm going to let you answer that. But when I asked you if there was anything in the text messages that caused you to pause and it would in some way affect the impact on your evaluation, your answer to me was no.
It's not my complete
I
answer.
understand. But was your answer not to me no?
Yes, but that is not my
Right.
complete
Now,
answer.
at the same time, Dr. Warner, at the same time, you expressed that they had a volatile relationship.
That is not the totality of my answer either.
Okay, and I'm going to get to it.
Okay.
But part of your answer was that they had a volatile relationship.
Correct?
And this is in relation to my question about the text messages. You agree?
Yes.
After you said no, you said they had a
This is in front of the jury. He is yelling at the expert, saying, I don't want your answers. I only want the part of your answers that fits with my narrative.
Yeah, again, this is not a look. You are trying a case based on domestic abuse against a woman. You were
Yeah.
not this way with your expert. This is going to reflect badly, especially if there was, let's take the DV victim that's potentially on the jury. A loud, aggressive man cutting off answers while trying to defend his client against, DV, giving his, it's optically, it is terrible. He should have had, today, Junior, do this because this looks like, okay, he's a bully,
is
she's a
battering.
bully. I would not be handling this well if I was a juror. I would be resorting to F words in my notes.
Why is she pushing back? Because he's totally misstating her answers, and because she don't agree with him.
Well, and she's been an expert for a while, so I'm sure she's had other defense attorneys try to do this, and
Yeah.
she wants to let the jury know, I may have said that, but that's not my full answer. So it does give the jury an idea that he is cherry picking. She is not a not clever woman. She is able to fight back and verbally spar with him, but she is able to do it in a way that's composed, and she is keeping her calm even as he's yelling and being fairly aggressive.
And it's not for the judge to stop the battering until the state objects to it, unless he starts screaming and punching at her. Just say your attorney can clarify or something else clever instead of, yeah. As good as people said that the weak defense or the weak state response to Sarah when she was on the stand, because that, I think they were thinking about that DV victim as well. This, I think, is a mistake.
volatile relationship and that she text message calling him an idiot, a fucking idiot for overdrafting her account.
Correct?
And in those text messages, there was some reference to domestic violence between the two.
Correct.
And that demonstrated to you that they had a violent relationship.
Correct.
And do you not agree that that evidence of a volatile relationship had an effect on you expressing your opinion here today that Sarah Boone suffered from battered spouse syndrome?
Judge, you need to object. You need to approach.
She didn't testify to that. Mo, I was just looking in my cupboard.
Yes.
I do have a mini moo.
Ooh, is that I'm guessing it's not a string cheese because I was
It's a
thinking,
chocolate.
ooh,
Jamie's favorite in skildpadde, or as she called it, a skildipede.
skilled. Yeah, that's kind of what I would have said. So Jamie is right. Midwestern is strong.
Some French
Ooh,
nougat.
now that looks good. I love the Italian nougat, and you don't get it often because it's very expensive here in America.
I have some scrapyard. I have a pepper licorice chocolate stick. I have the one, the only, the Yankee bar.
Oh, well, those are good because those are Mars bars.
No, they're Milky
Ooh.
Way bars. And I
Is
have a
that
gold bar. This one is with some. It's called. It just has a
is it
little texture to
honeycomb?
it. No, it's just a chocolate bar with a little bit of
Oh,
something in it, like a caramel something crunch. If Jemima can get a closing argument bingo up and running, if we're getting to closing arguments tomorrow, and we only have one winner, I'm going to preference this. If we only have one winner, it'll go to them. If we have multiple winners, confirmed winners, I'll do a spin on the Wheel of Destiny, and you
that
can
sounds
you
good.
can win. Only other preference is you have to be subscribed to either mine or most channels. So if we can get the closing statement bingo up and running, I'll be giving this away tomorrow.
So this was supposed to take 30 minutes each side. And then we were going to have the 2 hours of body cam. Then I think a couple of ancillary witnesses. Why do I get the sinking and disturbing feeling that we are going to be going for closings on Monday?
I don't know. But yes. It's and I don't think it's a good look.
I don't. I think again, there's a way to be very pointed, to be very clear, and to impeach her without looking like a giant douche canoe butt monkey.
Thank you, Jemima. They just went to lunch. Someone is skipping ahead. Let's see what the judge say. Then we can go to lunch. That means I have to set up an afternoon stream.
The
But-
judge is going to be like, pregnant pause, I'm out. I'm going to get a Frosty. I'm going to get a Baconator, and y'all better have figured out your ish when I get back.
Tappy Whisper. Thank you so much. We strive to be at least mediocre.
Yes.
On a good day, we will hit mediocre at least for less than 5% of the stream.
We try. We aim to please.
Oh, and while we are doing nothing, I have an announcement. Mo and I, and Jamie, if she can get out of her spunk-related, why have I, isn't it day 3 on? Why have I put it as day 3? Spunk-related incident. We will have our Stabuday on Saturday.
Ooh, yes.
And this Saturday, alternate juror AJ will be a guest on the show. She's a first-time angel, so I hope a lot of you will swing by at 9 a.m. Saturday morning and say hello to her. She's a smaller channel that I was on with roughly 3 weeks ago. Nice lady.
Members of the jury, it is 11:55. At this point in time, we're going to go ahead and take our lunch break. I'm going to give you a similar instruction that I've given you throughout the last couple of days. Give me a moment to pull it back up. Jurors, you must not conduct any investigation on your own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people and places involved in this case. This applies whether you are in the courthouse, at home, or anywhere else. You must not visit places mentioned in the trial or use the internet to look at maps or pictures to see any place discussed during the trial. Jurors do not watch local news or read local newspapers. Jurors must not have discussions of any sort with friends, family members, or even your fellow jurors about the case or the people and places involved. So do not let anyone make comments to you or ask questions about the trial. I want to stress again, bless you, that just as you must not talk about this case face-to-face, you must not talk about this case by using an electronic device. You must not use phones, computers, or other electronic devices.
Thank you so much, Marissa, for giving me
for your jury service.
3
Do
corner
not discuss this
kisses
case
over on
or
Buy
ask
Me
for
a
advice
Coffee.
by any means at all, including posting information on an internet website, chat room, or blog. With that, members of the jury, we're going to be in recess till 1:30, and we'll pick up at that point. Thank you so much for your service.
We're going to be back at 1:20.
Ooh.
But yes. And now Mo has the links. No,
Y'all may be seated.
that wasn't the link.
State, anything else?
That was my text.
Defense? All right, we'll see you at 1:30. Thank you very much. Court's
I
recess.
was wondering, I was like, almost looks like something, but
Oh, that was Marissa. Thank you so much, Marissa, for the 3 corner kisses on my buy me a coffee thing. And Iris, best mediocre there is. We strive. Strive to be the less crap option out there.
yes. And I know that my days are a little off because we had that first day where we thought we were going to get through jury duty. So I do have the dates on each one of my Sarah Boone Trial days so that you guys can follow, because I know I am often counting, but I stick with a system when I have it. Not to mention, I just dance to the beat of my own drum. What can you do?
Brandon, do I want to know what you did while I was looking away? Fixed it? Do I have to? Oh, Brandon deleted a message. Brandon deleted another message. Brandon's screen. Brandon doesn't do it. It's his screen. And what should the Sarah Boone book be called? 42% says sip it. I did it, not intentional, 31%. How to lose 103 pounds in one night, 17%. My struggle, sorry Mo, only 7%.
Yeah, it would have been funny to me, but probably pretty offensive. So I'll go ahead and let Sarah just keep, not without my zipper or a tragic wardrobe malfunction.
Yes. If and when we ever get to closing arguments, I just made a trip into my closet, so we will do a bingo. During closing arguments, Alkylex will be the free word. And try and ship something out.
Awesome sauce. We will be ready to go.
Thank you for fixing my mistakes, Brandon. Without you as a mod, how many troubles would I have to deal with myself all the time? I'm lucky I have you.
Yes.
More wrenches to Brandon. Him and Valhalla should be the only branched.
They really should. I just love Valhalla every time he gets a wrench. It's so great because he has wrenches everywhere. And then people misguidedly give me a wrench, like I know what I'm doing.
Luckily, no one gives me anything. Is that a
I
Dolly Parton
continually
shirt? Yes. This is my Dolly Parton shirt from when I was in Tennessee on a wonderful trip where I met Brandon because he was the guy who said I was having to come to Tennessee. Oh, wait. That's my name. Don't wear it out. Shh. Is the title of a book.
Shh. The quiet, terrifying love story.
I don't think anyone else caught a stray, but may want to check. No, I can only. It was butterflies and alibis. You showed your hatred. You deleted 3 of their messages, 4 of their messages. 5, 6, 7. Yeah, you deleted all their messages. I hope butterflies and alibi. Did you block them? No. I don't know. Are they all for lunch? They are all for lunch. So are we. And someone asked about why we don't do the word game anymore, because it didn't work for a week. So I kind of got into this 2 streams a day It'll help with the algorithm. I don't care about that. So if you hide someone, it deletes them all. It's your fault. No, Brandon, it's my fault. I gave you the power of the wrench. No, it's a-okay. And I hope butterflies and alibis don't take it the wrong way. If so, Brandon, sorry, he didn't mean to. He just have pre-wrench deletions.
What exhibit are you referring to?
I'm going to make this 100, Your Honor.
All right.
100.
100.
Because it is 100%
100%.
correct.
So you literally built a cannon?
Yeah, it's pretty awesome.
All right, I'm in love.
Go back. Please do that again. Oh, that was the cutest thing I've ever seen.
While I'm waiting for this, did you, whether it's true or not, believe that Mr. Randolph had slept with your wife?
I wouldn't care.
You wouldn't have cared?
No.
Did you believe he had slept with your wife?
No.
Did you believe he slept with your mother-in-law?
Probably did. Everybody has.
So there-
Everybody has.